right, welcome folks to the Appellate Division First Department. I have a note here that says we have over 5 hours of requested oral argument time. By my calculation, simple math, that kicks us till 7 o'clock at night. I'm not so sure if you folks want to be here this late, but having said that, please give me the time that you think you need to make your point. We have read everything, so we know what's going on. That said, first case up, People versus David Calderone. 6, 4, and 6, please. All right, 6, 4, and 6. Dan versus City of New York. 5, 2, and 5. Thank you. Nelson L versus June H. Okay, any respondent here? You still want 13 minutes? How about I give you 5 minutes, all right? You make your point, thank you. Number 4, Seagul versus VRH Construction. 5, 2, and 5, thank you. People versus Gilberto D, that's submitted. Masumi versus Ganju. 5 and 3 and 5, thank you. Just so you know, just so to remind you, the light's for you, not for us, okay? AMK Capital versus Seafree Realty. 5, 3, and 5. Okay. Kravitz versus Chicken Soup for the Soul. You're here by yourself. Do you want to submit? Okay, 3 minutes. Art Specialty versus HDI Girling. Okay, 5, 2, 5, and 2. Got it, thank you. People versus Darrell Thompson.
For appellant, 5 and 2.
5, 2, and 5, thank you. Hall versus Middleton.
For appellant, request 8 and 3. Respondent request 5.
All right, we get 5, 3, and 5, thank you. Patterson Belknap versus Marcus.
Your Honor, appellant Marcus Antonelli and Marcus asked for 7 and 2. Your Honor, appellant Antonelli requested 5 and 2. Respondent request 10.
All right, I'll give you 5. Appellants Marcus Sinelli and Davis Marcus, 5 and 3. Appellant Brian Sinelli, 5 and 3. And the respondent, 6. Okay. Ruiz versus Losita, that's submitted. Voram versus Voram Hicks.
Appellant 5 and 2.
No respondent. You're going to be arguing on yourself, against yourself. 3 minutes, okay. Number 15, Greenwich Insurance versus City of New York, that's submitted. Okay, folks, first case up, People versus Daniel Calderone.
Good afternoon, Your Honors. Catherine Pecor with Legal Aid Society on behalf of Daniel Calderone. I'd like to focus on point 1 of our brief because I think of all the troubling things that happened in this case, the jury misconduct was the most troubling. Juror Charity Boot clearly and unequivocally informed the court that she heard juror Teresa Lee remark that the trial was not going to last.
Yeah, but didn't the court conduct an interview with both jurors and asked the first juror about what she had heard. And then after that juror explained and told the judge what transpired, he then interviewed the second juror.
That's correct, but this inquiry fell far short of what was required to protect Mr. Calderone's constitutional right to a fair trial by an impartial jury.
Why?
Because at the end of the court's very limited inquiry, and this entire issue spans 10 pages of transcript, it's not a whole lot, and at the end of that inquiry, the court was left with two diametrically opposed accounts of the same conversation. And instead of reconciling the discrepancies, the court simply took both jurors at their word that they could be fair and said, quote, "I don't know if there was a misunderstanding as to what Lee said." I don't know is not, it's well short of what is required for a Buford determination. And the one thing that courts do not have the discretion to do is to speculate. And this was, I think, even falls short of speculation because it's almost a refusal to make any determination whatsoever. That was an abuse of discretion. And I'd just like to point out that I'd like to draw the court's attention to the Court of Appeals case Fisher that just came out this morning. Apologize for the late notice. But Fisher reiterated what this court has already held and what the Court of Appeals
How
held
do you
in
spell
Torp.
Fisher? That just came out today?
That's correct, this morning. And that was a case where
How do you spell Fisher? F-I-S?
S-H-E-R.
Okay.
And I do apologize, I was not able to print copies, but I will upload it tonight.
Don't apologize. I mean, that's,
But the bottom line of that case is that these type of comments that go to a defendant's character, negative beliefs about a defendant's character based on information outside the record, outside the evidence, are the most serious type of disqualifying bias and misconduct because they can't be rebutted with evidence. If you think, quote, that Mr. Calderone is not a good guy, I mean, there's no amount of evidence that's going to undo that bias. And under those circumstances, a very robust inquiry is required and the strongest assurances of impartiality. And in fact, Fisher noted that it's not enough for a juror to just kind of say, yeah, I can be fair, in response to relatively pat formulaic questions. And because of the severity.
I mean, I'm looking at my notes. I mean, this it all came down when she just said, go Google him, right?
I believe that was defense counsel's inference from that comment, but what she said is, you should look him up. She said the trial wouldn't last very long because it's not a good case.
Yeah, but then but Ms. Lee has also, when the judge made the inquiry, said, I didn't look up the defendant. That's my notes, unless I'm incorrect. She said, I didn't look him up. When she said, go look him up or go Google him, that's, I guess, what she just said. But that didn't, so that the clarification was, I mean, of course, at that point, you want to know if actually Ms. Lee herself looked him up. And she's unequivocally said, I didn't look him up. I didn't do any.
So a couple of things on that. One, the inquiry did not, Lee, the accused juror, did not directly address the comments about not a good guy, not a good case. She was not specifically confronted with that. But there's a whole other aspect of prejudice here that I think my adversary kind of ignores, which is that even if the court did everything right, and even if both jurors were being totally honest and it was a misunderstanding, what defense counsel repeatedly emphasized is that Charity Boot heard this in a very prejudicial way, and there was undisputedly at least one other juror present for this conversation. And we don't know whether that juror heard it, chimed in, was prejudiced by it. Even if both these jurors who were questioned could be fair, the point at the end of the day is that the court was required to identify and question every potentially affected juror in the case, and the inquiry did not do that. Neither of these two jurors were able to identify the third.
Counsel, if I may, I'm not familiar with Fisher, and of course we have to read it, but it just seems to me from, reading the transcript that the court pretty much, questioned both potential jurors in an extensive manner. And really what we have here is a credibility determination. The court credited Ms. Lee's, explanation. And so usually that's, deference given. So why should not be done in this case? And so, and you're saying, oh, we should, question the other jurors. But if the court credits Ms. Lee's testimony, what's the purpose of questioning the other potential jurors?
Well, first of all, the court credited I think implicitly credited both jurors' testimony.
Okay, well,
So if Boot heard something else, that's a problem too. It's about the effect on the jury. But also, I would disagree that this was really a reasoned credibility determination, because the court straight up says, she says, Lee candidly indicated she did make a comment, and then the court said, I don't know if there was a misunderstanding. That's like, that doesn't even rise to the level of speculation. That's not a factual determination. The court had to meaningfully resolve these discrepancies. It was like ships in the night, these two different stories.
and they-
could not both
and the
be-
court did. The court did.
I don't know is not resolving it.
Okay, thank you.
Thank you.
You have rebuttal time.
Good afternoon, Your Honors. John Hughes for the people. First, although many of defense counsel's complaints in this case are focused on the adequacy of the court's inquiry, I think it's important to remember that defense counsel only asked for inquiry before the court went through this, as Your Honors noted, pretty thorough
Do you
inquiry.
happen
with
to
both-
have a chance to read the Court of Appeals decision that came down today, People versus Fisher?
I had a chance to look at it quickly,
did?
shortly before the argument.
Yeah, I'm looking at it right now. I just read it. The beauties of modern technology. It doesn't really square with the case that we have in front of us, right? In Fisher, the juror, this was during deliberation, wrote a note saying that she thinks she was followed by the defendant. And at that point, the court did the inquiries and everything, and the Court of Appeals says, look, at that point, you have a juror who's now concerned for the safety and everything, and there's a bias there that's going on. This is totally different. This is before any testimony was heard. And in addition, the court did do its inquiry into whether or not the juror, Ms. Lee herself, because she's the one who started everything, what does she know and what does she do, and whether or not she still can be fair, correct?
Oh, I agree, Your Honor. I don't think the facts of Fisher are really anything like this case in particular.
No.
And I think in Fisher, the court also noted that, first of all, upon that inquiry with that juror in Fisher, the juror gave kind of equivocal responses about whether she could be fair and impartial, and her apparently mistaken belief that the defendant had followed her home. That's something that juror in Fisher also injected into deliberations.
Right.
And that juror in Fisher also waited 3 full days before even bringing any of this to the court's
All
attention.
very different about what happened here. This all took place well before the first witness was called, right? And-
Yes,
and-
yes,
And
I
the judge
agree,
had an
Your Honor.
opportunity to, I did it a long time ago, but I used to have to make inquiries of the jurors too, and make the call at that point, right? And it's in the record in terms of what transpired in the discussions, correct?
Yes, I agree, Your Honor. And I think also, once Lee actually testified, I think she provided a pretty compelling explanation for what happened and why there was apparently this confusion between her and this other juror, juror Bout. I don't know if I'm saying her name properly. But
Your adversary expresses concern that the judge, in her view, equivocated as to what version of the story was correct. What do you have to say about that?
specifically whether the judge equivocated or the
Yes,
juror?
I don't know what really happened, here.
Sure. So I think when the judge was ruling on this issue, she said, like, I don't know if there was misunderstanding. I think that was really just a colloquial, maybe even a verbal crutch that many people use when they're sort of suggesting what seems like a potential explanation for something. So I don't think that the court's using the words "I don't know" before discussing why she thought like a good explanation here was just a misunderstanding should be taken to mean that the court like had no idea what had happened. And especially when you considered in relation to Lee's testimony, she explained that Juror Bout had said something to the effect of, "Oh, I can't even read the newspaper." And then Juror Lee responded to her, "Oh no, you can read the newspaper, just don't look him up." And then later Juror Bout went to a court officer and said essentially, "Oh, I think this other juror said I should look him up." And so I think there's a pretty compelling explanation for how there could have been misunderstanding here.
But the jurors, the two jurors who inquiry was made of, they didn't give consistent versions of what occurred, did they?
Well, I would say this. It appears that their testimony, I think it could be reconciled in the sense of I don't think either of them was lying about anything that happened. They just
Well, there's
one juror
whether
mistaken
they're
the other.
lying on the one hand and whether their testimonies can be reconciled on the other. So let's say they both verily believed in their own versions. If we're left with that, what should have happened? Because those are two one is a very innocent explanation and the other shows that there is a real concern that a juror maybe has at the very least may harbor some sort of bias against the defendant and/or has done some independent research on that defendant.
Well, all right, so if both jurors are credible here, then first of all, juror Bout doesn't need to be disqualified because she didn't do anything wrong. She clarified she didn't accept any purported invitation to do any outside kind of research, and she said she could be fair and impartial. And if we also credit Juror Lee, who said that she didn't do any outside research and that she'd only made some very generalized complaints about jury service that really amounted to friendly commiserating or small talk, then there was really no reason to discharge Juror Lee either.
But then we are crediting two different narratives. We are crediting two different narratives to leave both of those jurors on the case. Presumably, there's only one truth or one set of facts that a judge could find, and then there have to be consequences from that. So, do we know? Did the judge explicitly state which narrative she believed, or was concluding was the narrative that controls?
Well, the judge did say that, noted that Juror Lee had said that she had not conducted any outside research. And so I think, read in context, I think the court is clearly crediting Juror Lee's explanation of what happened to find that there was no actual misconduct here.
I guess the way you could look at it is that Juror Lee tells the other juror, well, go look it up, or you can look him up. And that juror didn't do anything of that kind, so that sort of invitation, go do your own independent research, didn't go anywhere. It fell flat. So then the next inquiry is, did Juror Lee herself do any inquiry or any investigation? And she flat out said, I didn't. So in terms of, I guess that's where it goes to, right? You peel it back in terms of where the problem is, right? The one juror said, the recipient says, and there's always a case when someone says something, what they hear and what they say are always going to have like interference. They're never going to match up. But the court, I guess, in this sense here, was satisfied that the juror that received the information didn't act on it, and the juror who gave the information didn't do anything either.
I agree
Is
completely,
that,
Your Honor.
is that why she said there was a misunderstanding and she made a credibility determination?
Yes. I think that's the fair inference to make from the judge's ruling.
Okay, thank you.
My time is up. Thank you, Your Honors.
I think that if the trial court had actually reconciled the stories in the way that respondent is suggesting, we'd be having a different conversation today.
You don't really need a reconciliation. You just need to, the way I look at it is the trial judge had to satisfy with himself that the juror who heard the information didn't act on it.
That's right.
And that juror convincingly told the judge, I didn't act on it. Then the next question, at least from my mind, is that whether or not the juror who gave the information did something. And that juror unequivocally said, I didn't do anything either. There was a misunderstanding. Regardless of whether or not there is a misunderstanding, both jurors, in my mind, maybe in the trial judge's mind, like, didn't do anything outside of what they were told they shouldn't be doing because neither of them did it. Right?
One thing that inquiry did not resolve is the not a good guy, not a good case comment. But also, I just want to remind the court, we're kind of avoiding one of the largest issues here, which is that somebody else was there. Why not figure out who that person was and question that person because there is this clear discrepancy. And I'd just like to note, Justice Ong, you were referring to the procedural posture of the case. This happens early, right? It's before even the defense's opening statement.
This case is very different from Fisher. I read the facts.
I'm not citing Fisher for the facts. I'm citing Fisher for the principle. But what I'm saying is that the fact that this happened early in the case, that cuts the other way, actually. Because before any witness has been sworn, this is the lesser cause challenge standard. If there's any likelihood of bias, why would you take that chance? I mean, what's the harm of doing a little bit of additional inquiry to protect that constitutional right to a fair trial? I mean, something more is required, and there is absolutely no prejudice to anyone by simply taking the time to do that before the case is really even underway.
What import do you give to the curative instructions that were given by the judge, the admonishment to the jurors?
I read that as essentially the standard instructions that the court gives at the end of every day, saying you're not to do X, Y, Z. It was not directed to the conduct specifically, and it was not prompt. So I don't think that would have done anything other than what the jurors had already been told.
Okay, thank you. Dan versus City of New York. Okay, counsel.
Good afternoon, Your Honors. May it please the court, I'm Lisa Como for the plaintiff appellant. So this case has given me an opportunity to explore the world of door cases. And it's a relatively small subset, and there's a couple of things I think that I can say about it from the start. One is that the law does recognize defective door closing mechanisms, first of all, as actionable and as a basis for recovery when a person is injured by a defective door. There are virtually no cases about door stops, but in this case, I think it's also important to look at how the two things-
Let me focus on one thing that the plaintiff testified to. That's your client, correct?
Yeah, yes, Your Honor.
Your plaintiff said at her deposition that all the doors in the building except this one had door stops, right?
I think, I looked at that. She said at page 252, other doors had door stops, and I think it's possible that I may have actually misquoted that as saying all the other doors. I don't know.
No, I looked at the deposition testimony, because he says right here that it says, did other doors have it? Yes, the door stop. So doesn't that lead to one to conclude perhaps that there is at least constructive notice, in a sense, on the part of the defendants that why, in my mind, it's like, why is it all the doors except for this one have door stops? And I didn't see a good explanation in the record here about that.
Yes, that's actually
It
part
wasn't
of our
that bad of a
point.
question when you were getting a little nervous about the question, right?
But you know what, I
because
wasn't
it's all,
sure.
look, everybody acknowledges there's a doorstop missing, right?
Yes.
So the question is, well, okay, in my mind, maybe my colleagues would disagree. I'm wondering, why is it that you stopped at this door?
Right. I didn't want to be misleading in case I was wrong. I know that in respondent's
No, we
brief,
do our review of everything. Don't
they
worry.
mentioned something about a photo, and I can't say whether every single other door, but that was the testimony, that these entrance doors all had door
Well,
stops.
in my mind, it's there, right? I mean, it's clearly it's there, so that if you're moving for summary judgment, you're gonna have to explain to me at least that's one factor that you're gonna have to explain as to why this door didn't have a door stop, and maybe not all the other doors, but at least that's simple enough to just count how many doors and how many door stops you have, right?
I mean, Miss Caraballo, if I'm saying that right, who was the
engineer, the custodian
engineer, the
engineer,
school
right.
engineer, she said she knew that. She was aware that it didn't have a door stop, and she also said something interesting, which was that
Well, no, the question, I keep going back to the same point. They didn't ask her about whether or not, well, about the other doors.
right, but she did say that she thought that this door was too close to the wall, and she was aware that it had no door stop, and there's never been any explanation as to why that condition was allowed to persist, and certainly it's our position that it should not have been. Not only, I mean, again, there are questions about the door closer mechanism. I cite the cases of Lugo and Siciliano, where this court
Let me
addressed.
ask you with respect to Ms. Caraballo. This custodial engineer did admit that or state that the plaintiff wouldn't have been injured if a doorstop had been installed near the door, right?
She did.
Did any of the defendant's witnesses rebut that?
No, that she is the defense witness. She
Right.
principally is
but
the defense
That was a concession, right?
Yes,
Did
absolutely.
Any of the defendant's witnesses testify to the contrary?
No, it's undisputed that it was causally related to the accident. But the court below simply said, well, the absence of a doorstop kind of in and of itself doesn't mean anything. There's been no proof even on top of that, because the speed of the door closing, as the plaintiff's expert discussed in his affidavit, those two things actually work together, and sometimes the absence of a doorstop can actually make the door closer mechanism be defective. And plaintiff testified that, and she's, a dean at the school, she uses these doors all the time, that, you should not open a door normally and it suddenly, slam open and be able to crush your hand against the wall.
Did
This is a
anybody
school.
refute the plaintiff's testimony that all the other doors had doorstops?
No, I don't believe
But for
that
this
was
one?
refuted. In fact, Ms. Caraballo admitted that she knew that this one did not have a doorstop. And you know, I can't say on this record were all of the other doors exactly the same dimensions and exactly the same space. However, Ms. Caraballo saying that it was too close to the wall and it wouldn't have happened if there had been a doorstop, and yet sort of admitting that she never did anything about that, I think certainly would raise a question of fact that requires resolution at
Thank you.
Thank
You have
you.
rebuttal time. Thank you.
Good afternoon, Your Honors. May it please the court, Karen Wolf for New York.
We're not going to hear you if you don't use that mic.
Sorry. May it please the court, Karen Wolf for the Department of Education and the New York City Board of Education. I'd like to start first with Justice Oing's question, if I might. So Justice Oing referred us to the plaintiff Dan's testimony in her deposition. This is on pages 251 to 252 of the record. And if we look at that deposition testimony, it's unclear what Ms. Dan is actually referring to. So it begins with, were there any, paraphrasing, not just paraphrasing briefly, were there any complaints with respect to the doors? No. Were you aware of any injuries? No. Then the question is, you mentioned a doorstop that you knew was missing. Plaintiff Dan, I did not know it was missing, not until that happened. Was there anything on the floor that should have been a doorstop there, like affixed to it? Is there usually a rubber doorstop or something? No, I did not notice until after I got hurt that there was no doorstop on the floor. Was there something metal that should have been holding the doorstop? No. Could you see anything on the floor? It was missing on that side of the door. Did the other doors have it? Yes. So the question is, what is the it in that sentence?
Well, you know, I mean, I appreciate you highlighting that, but at the way I look at it is you see something like this, right? I mean, to me, it just signals, because you're talking about doorstops in general, right? And all of a sudden, you mentioned, do other doors have it? I mean, I couldn't help but flag that, and like, okay. I mean, it's simple enough at that point to do you know, the engineer, the school engineer or whoever would just say, we have 100 doors, Judge, and only 5 doors have doorstops out of the 100. So this testimony that she gave is not really something that can conclusive as to whether or not, you know, the missing doorstop should have been there or not, or whether or not, rephrase that, whether or not that should have had a doorstop, right? I mean, it's, you make, this is your motion for summary judgment. You got to eliminate all issues of fact, right? It's and you to the and it's most favorable to the non-movement here, right?
Absolutely.
She makes the point. Not that hard to figure this one out, right?
Well,
Or to look it up.
If I might, Your Honors, that's not quite the point she makes. The last question to which she is referring is the something metal that should have been holding the doorstop. It's not the doorstop itself. So it's not abundantly clear that that is what Ms. Dan is referring to, but even taking the facts in the light most favorable to the non-movement and granting.
So let's talk about the logbook. The logbook that was supposed to be maintained by the custodian engineer, Ms. Caraballo. Ms. Caraballo testified that she usually tested all the doors, and she couldn't recall a lot of information off the top of her head because it was a long time ago, right? The daily logs have absolutely no reference to any door inspection whatsoever. What are we to make of that?
So Ms. Caraballo's testimony at her deposition, the continued deposition, I'm sorry, was that part of her daily inspection rounds included inspecting the doors, opening and closing, for the safety of all students and faculty. And she testified that she did that every school day, which included the preceding school day to the date of the accident, which I believe was a Monday. And then also the logbook demonstrates that an inspection was conducted.
The logbook shows door inspections?
It demonstrates that she conducted her usual inspection in her testimony then.
But the log is specific as to what the inspection consisted of, right?
I believe it's 2 sentences where Ms. Caraballo indicates what she inspected. And I do not have that exact record site in front of me.
Page 408. Do you note in any of these entries that you actually inspected the exterior doors. No, that's just something you did. You didn't have to enter it anywhere. Correct. So there's no entry with respect to an actual inspection of the door. But I'd like to go to something else because Ms. Caraballo, her testimony was very general with respect to inspections. Was there anything specific that she remembered that particular day inspecting that particular door? Because from my reading, I think she said it was so long ago, she could not remember. I didn't see anything that was so specific to that door.
Regrettably, some time did pass. This deposition was not conducted until 2021, probably in light of the pandemic. Some years had passed in between the accident and the deposition. If I could just, Your Honors, what Ms. Caraballo is testifying to and taking her testimony as a whole and in context is she makes the same inspections. So what she's saying is that the log itself does not designate that the doors were inspected, but she testifies that she did inspect them as part of her rounds.
So she's testifying to a habit and custom.
Absolutely. And
Okay, but habit and custom only permits the inference that the habit and custom was followed on the day of the operative event. It does not compel the conclusion that the habit and custom was adhered to.
I think, so Ms. Caraballo is a fact witness, and it is she who was responsible and she who testified to the inspections. And she says that it's part of her rounds to conduct the inspections, including the opening and closing speeds of the doors, and that she conducted her normal inspections as indicated by the logbook.
And
Counsel-
isn't the logbook also a place where she would request she would note if there were any issues with a door, any request to repair the door, anything like that would have been noted in that logbook?
Either in the logbook or in the repair requests. And thank you, Your Honor. That brings me to the point that the respondents had no notice of any possible defect. No one disputes that Ms. Dan suffered an accident on this day and that she was injured. The question,
That takes me to the constructive notice. No doubt about it, about the actual. But if we have testimony from the plaintiff that says there was a door stopper on every door that hasn't been refuted, then you have Ms. Caraballo's testimony that says, I did it every day. She gave us the time, 7 a.m., something like that, and no problem. So if we have a door stop on every door, but Ms. Caraballo says, but there was not one on this door, and she gives an explanation as to why it wasn't, doesn't that raise an issue of fact regarding constructive notice? I mean, if she's checking the doors every day, all the other doors have a door stopper, wouldn't she know? Oh, there's no door here. No door stopper there.
the respondents do not concede that Ms. Dan's testimony establishes that every door had a doorstop. And in fact, the photos which were submitted by the plaintiff show that there are other doors in the same frame which also lack a doorstop. So, or I shouldn't say the word lack because that presumes it should be there, but also do not appear to have a doorstop. So the premise is not that it was missing a doorstop, and Ms. Caraballo then prophylactically subsequently installed the doorstop. This also gets to the point that the building doors, all of them without refutation, were inspected both for fire safety and by the building codes. Plaintiff's expert came forth with unrelated violations, but could not establish a violation related either to these doors in any respect or with respect to a doorstop. So it is the respondent's position that this door did not lack a doorstop and that Ms. Dan suffered an unfortunate accident on the date. But the city had, to the extent that there was a defective condition, The city had no actual, the department, I'm sorry, had no actual or constructive notice of it, and the door itself was not inherently dangerous.
Thank you.
Thank you, Your Honors.
I would just say with respect to the regulation issue, we're not asserting that there is a specific regulation that requires a doorstop. However, proving that you complied with regulations is not the same thing as establishing, in accordance with good and accepted industry practice, et cetera, that there was no defective or dangerous condition.
And what's the dangerous or defective condition here?
I would say it's, number one, the absence of a doorstop when there should have been one. And I think there's clearly questions of fact as to why and whether, how many of the other doors in the building had one and why there wasn't one here. At page 384, Ms. Caraballo gives no explanation. She knew that it didn't have one, but basically says, well, I didn't think it was an issue, so.
But from a notice standpoint, the defendants would have to have established prima facie that they lacked actual or constructive notice of the absence of the doorstop?
I would say yes. And I think also they would have to establish that the door was functioning properly, because there also were allegations concerning that closer mechanism. And although Ms. Caraballo said she looked at it and opened and closed the door, the Lugo, the Siciliano cases, which talk about those types of mechanisms, require more than that, more than just an employee of the defendant saying, well, I looked at it and it seemed like it was fine. Should have shown and explained, and kind of going back to the issue of her inspections of the doors, what she did. How did she determine that it was closing properly? What is a proper closing speed? And as plaintiff's expert also explained, the doorstop and the door closer mechanism on doors like this, these are very heavy fire doors. They have this automatic closing aspect, and they should have, according to us, the doorstop. They work together because the doorstop also keeps the door mechanism from becoming damaged. And as Ms. Caraballo also said, as you use a door like this, the mechanism is going to, I guess, sort of lose some of its tension over a period of time, and that's expected. They also never established what maintenance was done with respect to that, if anything was ever done with respect to that,
Okay.
that sort of thing.
We got it. Thank you very much.
Thank you.
Nelson L. versus June H.
May it please the court, your honors. My name is Nelson Lin. I'm the appellant and the father of Skylar Lin. I'm here today to ask you to vacate the order suspending my parenting time, which suspended my parenting time from 50% to 0. The problem with the order that the court issued was that I was not given notice that the issue of suspension of parenting time would be discussed at that hearing. In addition, I was not provided the opportunity to have an evidentiary hearing concerning the newest allegations of child sexual abuse. There were separate incidents that started this litigation. In 2019, there were reports that my daughter was being inappropriately touched by the mother's boyfriend. That commenced the litigation.
So, you're an attorney, is that correct?
Yes, Your Honor.
You've made more than one allegation of suspected sexual abuse by the mother's boyfriend, am I right?
That is correct, Your Honor.
Have any of them been substantiated?
The 2019 allegations of abuse are currently being litigated. The trial is not even halfway over yet, and there are many more witnesses to be called. Subsequently, in 2022, new allegations of abuse occurred in the fall, and so that prompted my team to file an order to show cause.
And how many times have your allegations been deemed not substantiated?
Well, I believe there were, the case is still being litigated, but there were ACS investigations.
It's a simple question. How many of them were not substantiated? Or how many were substantiated?
I believe there were 2 substantiated, 3 were not substantiated.
3 were not substantiated. Okay.
And so what we have here is a deviation from the normal procedure in which.
Well, this was happening while the trial was going on before the family court judge, correct? All this came down, right? It was
This is correct.
He was holding multiple days of hearings on this, and the AFC brought an order to show cause.
That is correct. In October, I brought an order to show cause to remove the AFC because I believe that she was biased. The very next month, in retaliation, she bought this order to show cause to suspend my parenting time, which has resulted in me having virtually 2 hours a week supervised with my daughter for the past 17 months and running. During this time, my mother passed away, who was very close to my daughter. My mother was basically raising my daughter every other weekend growing up, and we had my daughter for 9 years, and towards the end of her life, she was not allowed to spend any significant time with her, including the past 2 weeks when she was in the hospital. And she passed away 2 weeks ago, and prior to that, I had requested the respondent to provide ample time between her granddaughter and my mother, and that didn't happen. She got maybe an hour.
So you said the mother passed away?
My mother passed away. Skylar's grandmother passed away.
Styler's not the mother of the child.
The child's grandmother passed away. My mother.
Sorry about that.
Sorry.
And so
But the mother of the child is still here.
mother of the child is still
Okay.
present. Sorry, Your Honor, if I wasn't clear.
No, it wasn't clear.
And so, in conclusion, there was not the proper process that was applied to these new allegations that are completely separate, with a separate set of witnesses, with a separate set of evidence, including video evidence that I've recently uncovered in 2022 showing abuse happening. And so what happened was there was just no evidentiary hearing. The Reynolds case speaks to that there was no witnesses called, that there was no evidence submitted, that colloquy cannot be substituted as sworn testimony. And of course, we know the Troxel case, which talks about the liberty interests of parents in the care, control, and education of their children. And so what we have here is just...
Okay, Mr. Lynn, we've got everything. Thank you very much.
Thank you very much, Your Honors.
Seagul versus VRH Construction. Okay,
Good
Counsel,
afternoon,
you're
Your
up.
Honors. May it please the Court, Michael Kazores from the Law Office of Eric D. Feldman on behalf of the defendant, appellant VRH Construction Corp. Your Honors, I think it's very clear from the record, particularly the deposition of my client's witness, Joseph Pointek, that...
You know, Mr. Pointer could have been a little bit more clear.
Well, Your Honor, there
He could have
was...
just said, like, look, we didn't have anything to do with Terminal C, and that was the end of it. Instead, he's adding a little bit more stuff to what
There was a line in his deposition transcript that both Delta and the Port Authority and the Supreme Court sort of fixated on, which resulted in the denial of our motion. However, if the court, both that court and this court, would just read the next page, it becomes abundantly clear what he was saying. The line in question is on page 401 of the record. He's asked, is it possible that GMA was also doing work on the baggage handling system that was also within the jurisdiction of VRH at Terminal C? And he says it could have been. And that's what the court relied on to deny our motion. However, it's clear from the next page of the testimony that when he was referring to, or when he said it could have been, to counsel's question about jurisdiction, he meant the area.
What? Say that again? He meant the area. What area? Terminal C or not?
He meant the area of Terminal C where the baggage system was later put in. On page 402, the very next page,
Right.
question. In other words, it is possible that VRH would have subcontracted GMA to perform work on Terminal C baggage handling system. Answer, not to my knowledge because we weren't installing the baggage system. Question, you were working on aspects of the baggage handling system. Answer, no, we built a room. We cleared the right-of-way, which had nothing to do with the baggage system. That's taking existing utilities or existing things in the building and relocating them to make room for the existing baggage room to come through. That's what the right-of-way is clearing a path for the baggage system to go.
So, counsel, this is the defendant's motion for summary judgment, right?
Right.
Aren't there questions raised here? Mr. Pointek testified that not everything that was undertaken by VRH was included in the contracts. He testified that there were over 40 different projects over a couple of years and that VRH hired the subcontractors for these projects. So that language that you were quoting on 401, that it was possible the GMA was doing work on the baggage handling system within the jurisdiction of VRH at Terminal C, how are we to resolve these issues on paper, given his testimony at so many different points?
Your Honor, it's clear that certainly he said that VRH was a construction manager for various projects.
And we know that there's a difference between the construction manager and the general contractor. So let's just be clear there.
Right, of course. But it's undisputed that Delta hired Vanderland for the construction of this baggage system and that Vanderland subcontracted that work to the plaintiff's employer.
At Terminal C.
At Terminal
Your
C.
client, from what you're looking at Pointex, is it Pointex? Deposition is like, we didn't have anything to do with Terminal C with respect to whatever injury that plaintiff sustained.
Well, that's true, because VRH had
It's
nothing.
the second page of that. If you turn over the page of his deposition, it clarifies what he said.
Right, because he was saying that what they had to do with respect to the baggage system was clear the space for the baggage system to go in. And that's when
His injury doesn't arise from that. It's him going up and down the ladder.
Right, during the construction of the baggage system. If your honors look at page 408, he very succinctly says, we came in, we did our work, leave, and Vanderland comes in and does their work.
Counsel, if I may, there's also deposition testimony from Pontac that VRH was also responsible for supervising and directing the work of, all of the subcontractors it retained.
Right, over subcontractors that it retained. It did not retain the plaintiff's employer. Vanderland retained the plaintiff's employer for construction of the baggage system after VRH came in and made space.
Who retained Vanderland?
Delta did. And Delta also retained a VRH for other work, which included clearing the space so that Vanderland could then come in and build the baggage system. Thank you.
Thank you.
May it please the court, Peter Cantone on behalf of the respondents. It's our position the court should absolutely affirm here. The primary argument...
Well, it's either they were there or they weren't there. And he's pointing to the testimony of the person who testified. On the one page, he kind of wasn't sure. You couldn't tell whether or not they were there or they weren't there. They were there or they weren't there. But then if you turn the page to 408, he was very clear. No, we were not there. We were not there. We had no involvement with the installation of the baggage. We were there just getting it ready for them to bring in the baggage installation. And the plaintiff here didn't sustain any injuries as a result of us clearing the area, but instead was, ascending and descending the ladder, which was after we had done what we were supposed to do. We were out of there. So how do you get around that?
I understand that the appellant's position is that they had nothing to do with this.
Right.
But that is not substantiated by the record here.
So tell me where that would prove your point, or at least...
Absolutely. The appellant, there's no question here that the appellant was a general contractor for dozens of projects during the course of this major capital improvement project.
I think they're disputing that. If I'm listening to what was just said, they're like, we were just construction managers. You were responsible for the subcontractors under us, but no more than that.
Well, one of the subcontractors under the appellant was the plaintiff's employer.
Right.
And their argument now is, well, the work he was doing at the time of his injury was not part of our work. But when you look at the testimony, that's absolutely not clear.
What testimony can you point to that shows that what the plaintiff was doing was in the scope of, or at least carrying out the duties for, VRH?
Well, multiple things in the record. Number one
All
is...
you need is one.
well, number one is the comment that he wants us to gloss over now, which is the comment about it being possible that this was within the jurisdiction of...
That's Poindexter's
I have
testimony, right?
I'm sorry, but I feel like we're missing the main issue here. the spatial relationship is irrelevant. We need to show that they're a statutory agent, right? And to be a statutory agent, the determinative inquiry is whether the party that would be charged as a statutory agent had the power to exercise control and supervision over the plaintiff's work. So the fact that they happen to be in the same, occupy the same space doesn't inform on that inquiry. So what is the evidence in the record that suggests that VRH had the power to supervise and control the plaintiff's work?
Well, the contracts absolutely provide that the appellant was responsible to supervise and direct the work, was solely responsible for all constructions, means, methods, techniques, sequences, and procedures. And the plaintiff's employer was a subcontractor of the appellant. And the other thing in the record, if I may, is the plaintiff's testimony. The plaintiff was specifically questioned as to whether he understood the appellant to be involved in the work that he was doing, and he said yes.
But again, involvement is not the question. It's, did the movement have the power to exercise supervisory control over the plaintiff's work? So the fact that many trades, many contractors are working around each other on this very large project, I think is rather irrelevant to that point. It's what if anything, suggests that that party had the right to supervise and control the plaintiff's work?
Well, the contracts themselves absolutely provide for it.
Well, I think I'm hearing what you're saying, that there is a contract here, the VRH had the employer as a subcontractor on various parts of this project. It's a huge project, huge undertaking here, right? In my mind, taking what Justice Higgins said, they're all these moving parts, right? They're all compartmentalized in these contracts, right? So, but in Terminal C, which is where the accident happened, did they have the authority to control the plaintiff's work in Terminal C? That's what I'm looking at, right?
Well, this is the appellant's motion for summary judgment. Yeah. And the appellant now is just insisting we had nothing to do with this. But when you peel that back, the appellant can't say exactly which projects they were responsible for. They say, oh, well, the contracts don't include everything. There's additional projects. And oh, yeah, some of them were in Terminal C. And oh, yeah, some of them involved this exact area where the plaintiff was working.
Vanderland's representative at deposition defined this as a turnkey project for them.
Well, the question about Vanderland's involvement is separate, right? Here.
Well, if Vanderland and Vanderland alone, big if, was responsible for the baggage carousel installment, then that would exclude other contractors from that, right? If.
Except that the appellant's witness, Mr. Pointek, specifically testified that part of their work included this area.
The area, but it's not enough to be in the area. You have to have the power to supervise the plaintiff's work.
Just by being there, the presence alone doesn't automatically expose them to liability, right? I mean, there have to be something more than just being there, right?
Well, absolutely, but they are something more. They are a general contractor. That's the term they used. Right. They hired the plaintiffs.
If they're a general contractor, then we don't have this discussion because a general contractor is covered under 240. What I got the sense from the briefs was that they were a construction manager, which is not directly expressly covered by 240. So now it's a question of, is the construction manager a statutory agent under 240?
Well, I would submit that they can be liable here as either a general contractor or as a statutory agent. And that's absolutely the point we make in our brief. And their own witness describes them as a general contractor.
Okay, thank you.
Thank you.
Your Honors, VRH certainly controlled and directed work, but it was work that VRH was hired to perform.
Counsel, I don't know how we get around Mr. Pointek's testimony that it is possible that GMA is doing work on the baggage system, GMA being the plaintiff's employer, on the baggage handling system within the jurisdiction of VRH at Terminal C. How do we get around that very precise
Your Honor, if you
statement.
just read the next page of his testimony, it's clear that by jurisdiction, he's referring to the area, the same area where the work was done, because VRH had to clear a path to allow for space for the baggage system to be put in. Once we were done with that work, then Vanderland, that was hired by Delta to put in the baggage system, came in to put in the baggage system. And
Yeah, I'm sorry, I understood your friend to say that by virtue of the contract that you had, you were responsible to supervise the work. How do you respond to that?
we were not responsible to supervise that work at all. We were responsible for creating the space that would allow Vanderland to come in to put in the baggage handler system. At the risk of beating a dead horse, I want to go to page 369 of the record. Question, did any of those projects involve a baggage handling system? Answer, we had projects involved with the baggage handling system, but we were not directly installing the baggage handling system. Do you know who was handling the installation of the baggage handling system back in 2015? Answer, Vanderland Industries. Did VRH have any dealings with Vanderland system with regard to the installation of the baggage system?
Counsel,
Answer.
does that answer the issue of supervision and control? I mean, actually doing the installation is really not the issue, right?
Your Honor, we were hired to come in and create a space so that Vanderland, who was hired separately by Delta, could come in and put in the baggage system. We came in, we created the space, we left. Then Vanderland came in, along with their subcontractors, including the plaintiff's employer, to put in the baggage system. It was during that work that the plaintiff was injured. Vanderland was the general contractor hired by Delta to perform that work. VRH had nothing to do with that other than coming in earlier to create the space that allowed that work to be done.
So did VRH retain plaintiff's employer?
It retained plaintiff's employer to do other work around the airport, not this project.
Thank you.
They're an electrician.
Okay.
Okay, gotcha.
Thank you.
Masumi versus Ganju.
Good afternoon, Your Honors, and may it please the Court. Case Thompson for Appellant Cyrus Masumi. With the Court's indulgence, I'd like to jump to the declaratory relief claim, which the trial court dismissed on the mistaken assumption that there was no possible relief that it could grant on that cause of action going forward. And I want to start with one example I think cuts through all the objections in defendant's briefing and also addresses the two principal concerns of the trial court on this cause of action. As mentioned in our complaint at Record 51 and in our opening and reply briefs, one of the actions that defendants took as part of their coup to wrestle control of ZocDoc was to swap out Mr. Masumi's name in favor of defendant Karaz as the proxy holder on various founding voting rights agreements. Now, these agreements cover shares that are owned by third-party investors, but these specific agreements determine who can control the votes on behalf of those shares.
My notes have me, unless I'm wrong, it says you're seeking a declaration that has all the actions by the board of ZocDoc since December 2015, almost 9 years of action, to be held invalid. That's quite a big declaration, right? And the other thing is that we're talking you've litigated or at least commenced an action against 2 of the 5 board members, right?
That's correct, Your
Not the
Honor.
entire board. So how do you get a declaration against 2 individuals and you don't have it against the board? Because by my math, you still have 3 other individuals who are majority, right? These 2 are minorities. On the board.
That's correct.
How would you
Judge
get
Thorne.
this? How would you get this declaration?
So if the court were to order the declaration as pleaded in the complaint, then it would only be actionable against those defendants that were in this case.
Well, what does that accomplish then? You got 3 folks who they band together and they vote together. You've accomplished nothing.
Well, it would not allow...
Except for these 2 board members who would be restrained or constrained to follow whatever the court tells them to do, which I'm not so sure we would do that. But how do you get around that? You don't have a majority.
Well, three reactions to that, Justice Owing. First of all, we would just need one of these declarations to be acceptable in order to reverse here. And it could be the extent that some declarations maybe sweep a little bit more broadly than others, but
Well, yeah, I think so.
and to your point, also, I think the second thing I'd say is these were declarations that were pleaded in the complaint. We might be in a different posture if we were talking about at the end of the case, if this is what a court entered as final judgment.
Counsel, how can a court issue a declaratory judgment against an entity that is a non-party?
Well, I think it would not be issued against an entity as a non-party. It would be only issued against the defendants in this case. And I think the best example of that—
I don't think what you're following, I don't think you're understanding the questions, which is, so what? So you have 2 out of 5 board members. You don't have the entity that's in question, doc. So what? You have 2 out of the 5.
Certainly, but not all the declarations concern board actions. For example, the first 2 declarations say, with asking the court to declare that defendants committed the fraud described herein. That has nothing to do with Zoff.
The plaintiff here seeks to be restored as the CEO. That affects the entity that's the non-party.
The entity would certainly might be affected, but
No,
its rights and
not might. Come on.
The rights and obligations of ZocDoc would not be determined by a declaration issued by a court. It would not have to honor the court's ruling on that front. Who would have to honor that are the parties in this case, Mr. Masumi and the defendants.
It sounds like you're putting the court through its paces without reason. It sounds like you're asking us to issue a nullity, the court system, that is, issue something that would basically be a 0 as soon as it was crafted.
I respectfully disagree, Your Honor. So for some of these declarations, for example, if there's a declaration that the defendants committed the fraud, they could not then go down, walking down Park Avenue, and declare that they never committed any said fraud. That would then be legally already determined by a court of law, and therefore Mr. Masumi, for example, might have a very ripe defamation claim based on them saying, oh, we kicked out Mr. Masumi because of his terrible management, while not mentioning that, in fact, they had kicked him out as part of a fraudulent scheme to take control of the company. Another thing that might be impacted would be indemnification rights.
Well, counsel, what about, the declaration that certain actions were invalid and dealing with the composition of the board? I mean, certainly ZocDoc is affected.
Well, ZocDoc would not be legally bound by the court's determination on that issue, but defendants would not be able to operate as if they were legal board members. It would impact the rights and obligations of specifically the parties, including the defendants in their capacity as board members.
Okay, thank you.
May it please the court, Chris Cariello for respondents. A plaintiff cannot bring a garden variety fraud case against individuals and use that as a vehicle to litigate a corporate governance dispute against an absent corporation. It's not a case against ZocDoc. There are no wrongs alleged by ZocDoc. There are no rights asserted.
When I read this, it was just unusual that, normally you see that they litigate against the entire board, every single member of the board, and the board itself, right? Because if you want relief, you can't just pick 2 and leave a majority go on the other, because I don't know what the other 3 are going to do, right? I mean, this is kind of, it's trying to tell 2 individuals how to act as board members, but there are other board members, and presumably they're acting independently of each other, right?
Absolutely right. It's beyond unusual. It's unusual because the essence of this case is alleged fraud that, of course, we dispute that allegedly resulted in some board action
That's down the road.
at a board meeting. But the company whose board was meeting is not in this case. And so unwinding all of this board action doesn't make sense.
I mean, the way I look at it, if I were to agree with the plaintiff in their position, right, that would mean that going forward, this case could be pointed to for those who are seeking a DJ, a declaratory judgment, against 1, 2, less than majority of a board. And how would that play out? I mean, that would be kind of...
Practically, it's unbelievably fraud. The purpose of a declaratory judgment action is to settle rights, right? Is to take an uncertain situation and say, okay, going forward, now everyone knows what's going on. At most, the declarations that are being requested here would cast some doubt, would sow some sort of underlying chaos, put a cloud over ZocDoc and the way that these individual defendants, more to the point, are behaving. Probably what would happen is nothing. I mean, if Mr. Masumi got his declaration, for example, that he's the rightful CEO moving forward of ZocDoc, I mean, what would happen? Would Dr. Karaz, who's the actual real-life CEO with real-life employees and real-life customers?
Adversary posits that ZocDoc does not need to be added as a party because and I'm adding language based on what we know from the documents, because 2 of the 3 founding members are defendants, and the 3rd founding member is the plaintiff. So because they have the 2 founding members yoked, so to speak, they don't have to worry. As long as they've got the 2 people who now are the majority shareholders, whatever declaratory judgment were to issue, that would be enough. There would be control. There would be compliance. There would be a change.
Your Honor, so first of all, ZocDoc would be free to ignore all of this, right? They're not bound here, and so they wouldn't have to in any way sort of follow these orders.
And if I were to follow up, I think the question would be, well, how? If we've got the 2 people who've got the votes, how could ZocDoc do something different?
So, Your Honor, if you're addressing the Founders Voting Rights Agreement, which is seemingly the only thing that plaintiff wants to talk about, even though if you look at R69 and 70, you will see no reference to the Founders Voting Rights Agreement. It's an attempt to come up with something that sounds a little bit more modest, but I do want to address it because plaintiffs emphasize it so much. So that declaration that Mr. Masumi, under these Founders Voting Rights Agreements, has forward-looking ability declared in order to vote all of these proxies would dramatically undermine the shareholders to these agreements who are on the other side of them. The way that these agreements work is they stipulate that the founders with a majority control get to vote those rights. And that's an important protection that was bargained for by these shareholders. It means that in a situation just like this, where you have a rogue, ousted minority founder who comes back 5 years later to try to exercise dead hand control, they can't do it because—
Well, we don't know that he's a rogue, do we?
Your Honor, we know that he's been ousted from the company, and we know that he's trying to wrest control of a company that's not interested in him controlling it. The absent shareholders in this case have rights under these agreements. It's their shares that are being voted. And so they have absolutely legal rights in saying that Mr. Masumi is stopped 5 years from claiming that he has rights under these agreements, that latches would apply, and that it contradicts the plain terms of the Founders Voting Rights Agreement.
I have a basic problem with when I'm hearing the arguments here is that the way this all plays out, if I were to agree with the appellant here, would be and issue the declaration against these 2 individuals, they couldn't exercise independent judgment. They would have to follow whatever the court declared. And that's not a role for a board member. I don't believe the court gets into the boardroom and tells board members, or at least individual board members, what they need to do to carry out their business. The remedy is to oust those board members by whatever means the agreements provide for, but not have the court inject itself into the boardroom.
It would be a deeply problemaul result.
Because I was
for the
reading
reason
what
you
they
say.
want.
Board members owe fiduciary duties to the board. And
the company. No, board of you owe fiduciary duties to the company, right?
Right, absolutely. And the idea that you could come in here and get declaratory relief without everyone who has an interest in it, and then create uncertainty in judicial.
But even so, even if you named everyone, you still have a problem whether you're injecting in there. We're now sort of, in a sense, the super board, because we're now telling the board members what they need to do and how they're supposed to do it.
It would be problematic even if the board and the company were here. The fact that it isn't means it doesn't pass. Thank you. Thank you, Your Honors.
My friend on the other side wants to talk about—
Well, what do you think of that? Is that a problem that I have? Or am I just, thinking too much about this? That You're telling two board members through this declaratory judgment how to act, how to conduct their business. Is there something wrong with that? I mean, the usual way that I've seen these cases is you oust these board members. You do some way, whatever the agreements allow you to do, you oust them, you get rid of them, but you don't have a court coming in telling them what to do.
Justice Owen, the court would be saying that they...
All right, I gotta stop you right there. We're not supposed to be saying anything for these businesses, right? We're not supposed to tell them what to do.
Not in terms of business judgment, but courts all the time absolutely issue declarations saying that somebody committed fraud. Somebody, for example, is not the rightful holder of a proxy vote under certain shares because they fraudulently...
That's not usually through a declaration. That's usually through a standalone cause of action, of fraud, ouster, removal, whatever the BCL allows you to do.
Well, fraud, like the claims that are continuing in this case before the trial court, fraud and conspiracy claims, are backward-looking. Those are for monetary damages.
Yeah.
What the claim here is centered on is current-looking and forward-looking.
Your client's looking to, the way I look at it is your client's looking to wrest control of the company through the court system, where he cannot get control through the agreements. That's the way this sounds like it's happening.
Well, there's certainly worse ways to take control of a company. We submit one of those to what defendants did. But in this instance, he's not trying to wrestle control. He's trying to have a court adjudicate the current and future rights of the parties. And we'd point you in the direction of the
and the declarations you seek are in his favor. They're going to give him control of the company if we agree with you and provide you with the declarations, or at least reinstate the DJ action.
As pleaded in the complaint, yes. Now, the trial court would not be bound.
So that means he's getting control of a company where he couldn't do otherwise.
Well, he might do otherwise if, for example, the board could fire the current management of the company knowing that they engaged in fraud, for example. So it would not legally bound ZocDoc, the rest of the board members of ZocDoc, from doing anything. It would only bind the parties to this case. Now, of course, the board members of the company might react knowing that, there's a judicial declaration of fraud. But I just wanted to point your honor specifically to the Pearl Securities case, which is cited in our opening brief, our reply brief, and not discussed or cited anywhere in defendant's opposition brief. And in that case, you had a court declaring who is the rightful holder of certain derivatives from shares of publicly traded companies. And the companies were not parties to the case, even though...
This is very different. This is not deciding who owns the shares and how many shares you own. This is totally different. This is you want a declaration of fraud has been committed, and that now these individuals have constrained or have to follow the declarations as X, Y, and Z, what they have to do going forward.
Well, some of the declarations, for example, H in our prayer for relief talks about invalidating the certain actions taken during the coup back in November 2015, and that includes changing the proxy holder, which is very much similar to Pearl Securities when it comes to who can vote on behalf of those shares of the corporation.
I got it. Thank you.
Thank you.
AMK Capital versus Seafree Realty. Justice O'Neill Levy is recused from this case. Good.
May it please the court. Austin Schufelt on behalf of appellant Adam Plotch. There are 3 issues of first impression before the court on this appeal.
I gather your main argument is the Travers hearing, right? You don't think a Travers hearing should be held?
Correct.
Right? Why? Because he's not challenging that he got the mailing. He's challenging the personal, the substitute service, person of the suitable age and discretion, correct? No.
No, insofar as it concerns this appeal,
yeah,
where the argument is that a Travers hearing was not to be, it was improper to hold a Travers hearing or to order a Travers hearing in light of the fact that there was no compliance with CPLR 3082's mailing requirement. Insofar as...
Oh, you're not arguing about the suitable age and discretion that being served on?
No, that was the basis for the...
That was the Supreme Court was saying that, unless I read the wrong case.
A Travers hearing was held. Or a Travis hearing was ordered. We're saying that a Travis hearing never should have been ordered, but the case
I
should
got
have been
that.
dismissed.
Yeah, that's, maybe we're missing with two ships passing in the night, okay? Supreme Court ordered the Traverse because the Supreme Court says, well, you got the mailing, there's one thing that we have to figure out is whether or not the summons and complaint was served upon someone with suitable agent discretion, because Mr. Plotch said that the person identified in the affidavit of service is a woman that he has no idea who she is. And in fact, it may be a neighbor down the hall. I don't know, right?
Actually,
I must be reading the wrong appeal. That's not this case?
Well, those facts are certainly present in this case. However, the
okay.
instant appeal concerns the fact that the markings on the envelope indicated the mailing came
So here's
from.
the question. The markings on there didn't say personal and confidential, right?
It did say personal and confidential. It provided indication that it concerned an action against my client.
Right, and the thing is that Mr. Plotch's, the address that it was mailed to, he uses it dually, both as a residence and as a business. And we know as a residence, you don't have the careful, markings that you need to do that, because if it's sent to a business, of course, you want those markings. You don't want everybody to know your business, right? So that's the
very crux of the, insofar as we're talking about that element or that branch of the appeal, that is the issue of first impression here. Whether or not, where it's conceded, the defendant was served at his place of business.
At what point is your adversary aware that the plaintiff's residence was used as a place of business?
I don't believe that information is in the record, Your Honor, but that was not argued by them insofar as they never contended in the papers that they did not know they were unaware of it being his place of business. In fact, it's conceded on page 18 of their respondent's brief that it is both the residence and business. There's no dispute before this court whether or not it was actually his business, and there's no controversy regarding the timing of when that was
sir,
learned.
under 3082,
Yes.
plaintiff would have an option. I can serve at residence, or I can serve at actual place of business. If we were to accept your reading here, where the defendant has simultaneously occupies the same address for business, actual business purposes and residence, would we be depriving the plaintiff of that option by forcing them to treat it as the place of business?
I believe the question there assumes that an option exists, but rather if you serve at the place of business, these are the requirements of it. There's no section of 3082 that says if you serve him at his place of residence, then you don't have to worry about the markings. It's just that if you served at his place of business, then you have to make sure that basically other employees aren't going to see it. There's a matter of privacy there.
Well, 308, my reading of 3082, and I believe Professor Alexander shares that reading, is that the legend is not required where the mailing is affected to the residence.
But that is correct, but that's not what we're talking about here. We're talking about the papers being delivered to a dual-purpose address, which is the issue of first impression. So let's take it away from this case.
Let's back up a second.
Okay.
In 2011, when the lien was sold at auction to Mr. Plotch for $10,000, and Mr. Plotch and the referee executed a memorandum of sale indicating that the sale was subject to a prior consolidated mortgage in the amount of $125,000. Was there any document that used any name or entity's name other than that of the individual, Mr. Plotch?
Mr. Plotch, I believe, I don't have it in front of me, but used his business address
No,
in his
I'm not
own
talking
name.
about the address because the address is the same. I'm talking about the name.
I would have to look at the deed to see if it says has an office at.
Well, you can look at it maybe while you're waiting to speak again.
Okay.
But
You have rebuttal time. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. My name is Megan Rowe. I'm here on behalf of respondents Magni McHale and Olga Garcia McHale.
Okay, so just to be clear, I want to, and from what I just heard, the appellant here is not challenging the service upon an individual now. He's challenging he's challenging the mailing aspect of the service here of 3082 by saying that it was a business and there should have been markings, right? So to be clear, we don't have to worry about what I thought was the person being served, because it seems like now that's out the window. That's not being argued. And that he doesn't need a traverse here because the mailing itself, without the markings, that's automatically a no-go. So
Your
is that what you're hearing too?
is correct, yes.
I mean, that's what you're hearing too, right?
Yes.
Okay.
While appellant has argued that the delivery prong of service was not proper as well, that's not the issue on this appeal. Respondents had originally filed a cross appeal with respect to the scheduling of the Travers hearing, but because a Travers hearing was held and a decision was entered, we have withdrawn that portion of the cross appeal because it's now moot.
The traverse was held,
And a decision was entered.
and I guess the service was upheld after that traverse?
Service was upheld, that's correct.
Okay. So what do you think about, well, I mean, it still leaves the issue about this address has a dual purpose. It's residence as well as business. And his argument is that marking on that paper, on that envelope, had no reference at all to any legal action whatsoever. What do you say to that?
Appellant is wrong. This CPLR 3082 has two options with respect to the mailing. It's in the language of the text. It's not silent on this issue. There's no exception seeking to be made. You can mail to someone's last known residence, or you can mail to someone's actual place of business with the privacy components of the personal.
Let's talk about the someone. You can mail to someone. Who is the someone, or what is the someone who purchased the lien? Was it the individual Mr. Plotch, or was it Mr. Plotch a business?
It was Mr. Plotch, an individual.
And as far as the memorandum of sale that was executed along with the referee, was that Mr. Plotch as an individual, or was that Mr. Plotch as some type of entity?
My understanding, Your Honor, is that it was Mr. Plotch as an individual who owns it.
So, you know, the way...
Looking at something on the record that tells you otherwise.
So to borrow Justice Hicks' earlier comment, you know, you have an address that has dual purpose, and based on the CPLR 3082, the plaintiff, the person that's doing it, can choose to treat it either as a residence or a business. I mean, either way, he's proper to, right?
It's not an issue of the plaintiff choosing. A home is a home. This is a residential address. The fact that appellant may work out of his home does not change the nature of the location from a residence to a business. Plenty of people work remotely, whether they're employed by an employer, they're self-employed. Someone may have an Etsy store, someone may have some other business.
Well, in fairness to your friend, the statute doesn't exactly expressly address this situation of a hybrid residence office. It speaks as though there are two mutually exclusive locations. And at the time this provision was drafted, which was probably about 1960, 1961, probably the prevalence of working from home hadn't taken hold. So I you know, in fairness to him, I think that this is, you know, a unique situation under 3082, and I think that's borne out by the fact there really isn't much law on this subject. I think the best we could come up with was a federal district court decision that Howard Johnson that was ruled in your favor. I think in a footnote that indicated that, well, where it's a hybrid situation, but because it's at least a residence, not exclusively, but it is a residence, the plaintiff can rely on the residence aspect of 3082.
I agree that is the decision we have that's actually addressing the situation. I think because it's a bit of an obvious one from the language of the statute. But
Well, so what would the rationale be for having that legend on an envelope that goes to a defendant's place of business?
privacy considerations with respect to everyone else in the workplace. On the same page in our brief, I believe is page 22, where we reference the Southern District decision, there was also a decision from the Supreme Court, Bronx County, James versus Brandt, which was decided in 1989, actually when the CPLR provision was amended to include that option of mailing at a defendant's last known business, actual place of business. Yeah. And the court noted that while service in that case was not proper, the purpose of the amendment and of those confidentiality provisions was to protect the privacy interests of employees who may be sued. So the person in the mailroom who gets the mail doesn't see that this is from an attorney with respect to a lawsuit, so their boss doesn't see it. But that consideration is not an issue when it's mailed to someone's home, even if they work out of it.
Okay, thank you.
Thank you.
And maybe you, sir, you could pick up where your friend just left off. If the purpose of that legend is to try to secure or protect the defendant's privacy, would that objective or purpose of this statute not be present in a situation like this where the person has a dual residence and place of business?
Does a funeral director who also lives at the funeral home, like many of them do, have no rights to privacy? Does an employee of a summer camp whose employer provides housing for him also have no rights to privacy?
I think that is an extraordinary overstatement compared to what I just asked. If the person is working at home and they have and that is their place of business, is the underlying purpose of the statute still applicable?
Absolutely. Why does my client have any less rights to privacy from his employees who happen to show up to his house, to a place where he also sleeps, versus if he did not sleep there? The fact that the property is used for an additional purpose does not change its nature from being one of a business address. And the rights to privacy are no less important or paramount. That just because my client also happens to sleep there, it does not change the fundamental nature. In fact, as per the deed that we discussed before into my client on page 468 of the record, it states plain as day, Adam Plotch, with a principal place of business at the address in which the papers.
What business did he conduct out of the
real estate? My client operates in the real estate industry, predominantly in actions that concern a mortgage foreclosure that has some sort of foreclosure attached to it. But it's a legitimate business.
Okay, and how many coworkers did he have at the time of service?
That's not in the record, Your Honor, but
who else handled the mail that came in for Mr. Plotch at that address?
Your Honor, it sounds like we're getting to, well, what's the idea of prejudice? When prejudice has always been wholly irrelevant to the questions of jurisdiction. In fact, the ability
I think the Court of Appeals would disagree with you in Ruffin.
The Court of Appeals has said explicitly, at least twice, as cited by us, Rochelle versus Risch and Macchia versus Russo.
Which both predate Ruffin, where Ruffin applied CPLR 2001 to forgive a minor technical defect in service.
However, this court itself has ruled just, in 2015, that before a court can exercise its discretion to correct an irregularity, it must have personal jurisdiction over the parties. That's Gershel versus Christensen. I can give you the pin site for it. It is, in fact, just last week, the Appellate Division, 3rd Department, came out with a decision saying, even assuming that petitioner's attempt to invoke the protections of CPLR 2001 is properly before us, the statute was not intended to allow courts to create jurisdiction.
Okay, one final comment is that if I were to agree with you about your saying that the markings here did not follow by the letter 3082, I mean, this whole, it's dismissible in that sense because you weren't served, right? I mean, that's what you're arguing.
Absolutely. The fact point is
so your only argument now is the markings on the envelope. That's what this appeal is about.
Time constraints have left me unable to go into RPA Bill 1331, but insofar as what we've discussed as to service of process, the defect is on its face.
I got it. Thank you. Kravitz versus Chicken Soup for the Soul.
May it please the court. My name is Jonathan Landsman. I represent respondent Susan Kravitz. She asserts one cause of action. She's a New York resident suing her employers under the New York labor law for commission wages earned in the state of New York. The court below correctly held that the venue provision in the confidentiality, non-competition, and non-solicitation agreement did not apply to claims for commission wages. This court should affirm. Commission wages are simply not covered by the subject matter of the confidentiality, non-compete, and non-solicitation agreement, which we sometimes refer to as Schedule B in the papers. There's a 3-page employment letter between the parties, which set forth my client's salary and referred to commissions. But that 3-page employment letter did not incorporate the confidentiality, non-compete.
Well, counsel, let me ask you this question.
Your Honor.
Page 9 of this multi-page agreement here, page 9 having the issue that you're bringing forth before us about having the going to Connecticut, right? Page 9 says the entire agreement. It says this agreement constitutes the entire agreement between the parties with respect to the subject matter hereof, right? So if I were to borrow your argument and the first 3 pages of this multi-page document is not part of the agreement, it's not part of this entire agreement, then does plaintiff even have a job?
Well, the answer is yes, she does have a job. You don't need a contract to sue your employer for wages. You need to have a job.
Now, you have to have a job, obviously, but if that's not part of this agreement, if those first 3 pages are not part of this, the venue portion of this agreement here, then it's not the entire, we don't have an entire agreement anymore, right?
If what you have is, like at a real estate closing, you might sign a deed, a mortgage, a title affidavit, a TP 584, that doesn't mean they're all the same document. Schedule
No, but it's
B,
all one transaction though, right?
It is a transaction, but Schedule B, which my client was required to sign,
Yeah.
no doubt about that, but Schedule B has its own integration clause.
Right.
And it specifically says that my client, there's no term of employment and it's an at-will employment. But that totally contradicts the employment letter, which starts at page R30, which says there is a 2-year term of employment at a guaranteed salary. So if you follow Schedule B to its logical or illogical terminus, you will see that it proves too much. It shows that it does not cover compensation. The commissions are in Schedule C, which is yet a 3rd document between the parties. And the bottom line is if the employer, a publicly traded corporation, wanted to incorporate the terms of Schedule B by reference into the employment letter, it could have and could easily have done so, but it did not.
So one quick question, if I may. The fact that the letter of employment followed by schedules A, B, and C, the fact that they all are chronologically numbered, that doesn't make a difference.
It does not change the language of the agreements. It means they were signed at the same time, but it doesn't make them one document. The numbering doesn't change.
And the fact that they were signed contemporaneously on the same day doesn't make a difference.
I didn't say it doesn't make a difference. I'm saying that it does not incorporate the terms of Schedule B by reference into the compensation agreement, because Schedule B has no compensation. And since it contains an integration clause, if it were the only agreement between the parties, my client would not have any compensation. And not even defendants are arguing that.
Okay, thank you.
Thank you, Your Honors.
Art Specialty versus HDI, Gerling.
Good afternoon, Your Honor. Ken Labate for the appellants. The question presented on this appeal deals with the scope of the duty to defend under a commercial general liability insurance policy. The lower court initially denied respondents' motion for summary judgment, finding that there were questions of fact as to whether they were entitled to summary judgment. And we think that that decision should be reinstated by this court because the motion to re-argue was granted in error. The reasons are because there were contracts at issue between the parties that were unsettled as to what their terms were. This issue has come now to be, I would say, born of fruition because the second department has now ruled as of last week that there are in fact questions of fact with regard to the contracts that are at issue in this case. And this was one of the arguments that we raised before this court on appeal in the companion case, Wilcox versus HDI, where we asked this court not to issue a decision on the scope of the duty to defend because the Kings County Supreme Court at that time and the second department were still wrestling.
Your bottom line is you're saying that you have no duty to defend the owner, SHS.
My bottom line is that there are still questions of fact in that regard.
Right, so if there are questions of fact, my understanding of duty to defend, you know, you look at the pleadings, and the fact that there's issues of fact doesn't mean that you don't have a duty to defend. Am I incorrect with that?
Well, I mean, that's certainly the law, but the duty to defend is no guarantee. It's broad as the court knows.
Right.
I mean, that issue's well settled, but there are exceptions, and we think this case does present an
And what's
exception.
one of the exceptions?
Well, the exception here is that the parties specifically contracted to what the scope of the duty to defend was going to be. And that language was mirrored in the additional insured endorsement that was on the HDI policy. And the carve-out to the scope of the duty to defend was that there was going to be no duty.
Right, the carve-out saying that amended, so, my notes have it here, hold on a second. The carve-out being that amend so the additional insured, which is the owner, right, is defended and identified arising out of the subcontracts TKE, that's your insurance, that's your policyholder, right?
Correct.
Acts and actions, and then it's amend also, so also all act, and it says, but is not defended or indemnified for its own acts, actions, omissions, neglects, or bare allegations.
Correct. So the but is obviously very important. And this is what we argued in Wilcox, unsuccessfully, but which we argued in Wilcox, and we think now has been borne out in the second department. Last week in the decisions issued by the second department, one of the issues that was raised was whether SHS was entitled to contractual indemnification against TKE under very similar language. And the court said that even though the 200 claim against TKE was dismissed, i.e. the general negligence claim, that TKE was not entitled to, that there was a question of fact as
So the second department came down and said it was the owner's fault?
No. The second department came down and said there was a question of fact as to whether they
Okay, so that goes back, well, then that means then you don't have to defend if it's for its own acts, and that hasn't been a determination. You just got a factual issue there. There hasn't been, that's why I asked if the second department came down and said the owner acts caused, then you won't have a duty to defend. Am I missing something?
No, I wish they would have gone that far. And
Yeah, they did. So which means you got to
What
still
they
defend.
said- No, we don't think so. What they said was that there was negligence, there was a question of negligence on the part of
Counsel,
SHS.
I have to admit, I don't understand how this is anything different other than a standard obligation to defend as opposed to an obligation to indemnify argument. If in fact it turns out that there's no liability, then you figure out who has to make a contribution towards the expenses that were laid out, right?
Yeah, I think the difference.
What's
and
so
I think
complicated
the
here?
difference here is, and we brought into the record the other agreement that exists between SHS and Wilcox. And I think if you look at the two agreements, they crystallize the issue, which is that the TKE SHS agreement was qualified by negligence, or that SHS was not entitled to any relief to the extent that it is determined that their acts or
Right.
omissions. And that would
There's been
apply
no
to defense or
determination, though.
indemnity.
To the extent it's been determined, right? So where's the determination that allows you to say, I don't have to defend them?
Right. Well, our position is there were other issues that needed to be explored and still need to be explored
Okay.
in the underlying action.
You find me a case that says that absent a determination of their negligence, I don't have to defend them. I take the position I don't have to defend them. I don't think that's the law.
But we would argue, and I do argue, that the same logic that applies to the duty to indemnify being pre.
Oh, no. Whoa. The duty to identify, duty to defend are two separate animals.
Agreed.
One to pay, and
Completely
one to
much
defend.
broader, completely much broader, but in this
Oh, yeah.
case, the parties have contracted as to what the scope of that obligation is
All
going
right.
to be.
I got it, thank you. I want to hear from the other side, thank you.
May it please the court, William DeVoe, Connell Foley on behalf of Respondent Arch Insurance Company.
Am I missing something?
No, I think that you're spot on, Your Honor.
There's been no determination that the owner was caused anything or was negligent, right?
There's been no determination. I think what.
Can you move the mic up a little bit?
Yeah, I'm sorry, Your Honor.
Thank you.
I think what appellant is arguing, and then again, he concedes that this court has already decided in the Wilcox action, which was not just one of the other dozen, if not scores of duty to defend cases this court has decided, but exactly the underlying case here, right? Except it was for the general contractor versus our insured, the owner. And the court looked at this provision, which appellant, I think, is claiming it's manuscript in some way, right? This is different. They've cracked the code on how to provide an additional insured endorsement that doesn't have to defend you.
Right.
And the court said, well, okay, no, we look at this as we will allow for you to not have to indemnify to the extent that the general contractor owner are found solely negligent. And that's how they.
Yeah, because if we were to accept that argument that the appellant made, that would change the entire landscape of duty to defend.
Correct, Your Honor, but also here I cannot, and I've thought about it quite a bit, I can't actually figure out when they would actually have to defend, because what they're saying is we don't have to defend if there's any allegations against the additional insured.
Right.
And that's just.
Regardless of whether or not it's been proven or not. As long
Correct.
as there's any, there's a hook there for me, I don't have to defend you. But that's not how the law is set up.
Correct, Your Honor. The duty to defend was triggered upon the filing of the tort complaint because the factual and legal basis for that indemnity were alleged therein. That's the law of New York as affirmed by
I
the
mean, actually, it's the first time I've seen that amendment where it says that, I don't have to defend or indemnify you if it's, you, the additional insured's own act.
Correct, and that, those are the contracting parties, and it was certainly inartfully drafted. The insurance policy that the appellant issued is a pretty standard form policy.
Gotta proofread those fine print, let me tell you. That's where it goes down to, right?
Yeah, well, agreed, but the additional insured endorsement is standard. It's typical. It's where.
But you didn't stop there, and you agreed to an amendment, right?
Right.
We agreed to the amendment, and so how do we give meaning and effect to that troublesome clause? Because unless it violates public policy, we have to give meaning to the contract. And so what is a sensible reading of that gives meaning to the amendment but is not defended or indemnified for its own acts, omissions?
Yes, Your Honor, it's a great question, and I think it was decided by this court, again, in the Wilcox action, that in giving everything meaning, the only way the court could determine it is this, that we were not allow an indemnity or defense once the owner or general contractor has been found to be solely negligent. Otherwise, it's nonsensical. So to give those words meaning, it comes down to the sole negligence of the indemnity or the additional insured. That's the only thing that gives it any sort of purpose if we're not just going to strike it out of the contract.
Okay. Thank you.
May it please the court, Sherry Pavlov for Respondent United Specialty Insurance Company. My sole purpose in standing up here is to remind the court that it did previously issue a decision which found that HDI had an obligation to defend Wilcox, and specifically said the fact that Wilcox might ultimately be found liable solely for its own independent negligent acts or omissions, which would not be covered under the additional insured provision, does not negate defendant's duty to defend it. There have been rumblings throughout the course of the summary judgment motions that were made about whether or not USIC, which insures Wilcox, has an obligation to defend SHS. That issue is not before this court. There is no record about it, and that was the sole reason I wanted to stand up. So thank you.
Thank you.
Just briefly. Much like I sat here and I heard the court say it didn't want to get involved in boardroom between shareholders, the court should not get involved in what contracting parties agreed to.
I guess the way I'm looking at it is this amendment here, this, as
Correct.
Mr. Seagul noted, it was a troubling amendment, is that the question I have then, does this amendment then now get rid of all that we have in terms of what's out there in terms of duty to defend?
No,
right?
I mean, in this case.
No or yes, it does? It sounds it does,
In
right?
this case, I think what Justice Leibowitz should have done was what he did initially, which was find a question of fact, let it play out in Kings County, see what happens in Kings County, and then come back and make a decision as to whether additional insured coverage was owed. That's what was
Oh,
contemplated.
so you're saying
by the
that
parties.
you're saying that let that issue of fact resolve itself with respect to the owner's liability.
Correct.
Once that's resolved, if it's
And it's
against,
right.
if it's not in your favor, you just pay for the defense costs. Is that what
I
you're
don't
saying?
even, Kings County has now found that there's a question of fact as to SHS's
I understand.
negligence.
I'm looking at the practical side of you.
Correct.
With this amendment here, I don't have to pay upfront the duty to defend.
Right.
But I'll pay the back end if at the end
They
of the day.
satisfy the contract. And the additional insured endorsement was not standard. The additional insured endorsement, unlike the one on the USIC policy, which I do want to address, was specifically crafted along with the language in the contract to eliminate the right to coverage to the extent that it was related to the acts of.
But this goes against what we decided in Wilcox, though. That's
I don't think it does again, we're talking about a question of fact. What was missing in Wilcox was the SHS Wilcox agreement. And the reason why I think that's important for you to consider when you're thinking about whether Justice Leibowitz was right in finding a question of fact is that we did raise in the answer that there were other insurance policies that may be obligated to provide a primary defense obligation. We raised it as an affirmative defense, and it's our position that the USIC policy, because it is a blanket additional insured endorsement with no carve-out like the HDI policy has, is required to provide that primary defense obligation to SHS. And therefore, at a minimum, there was a question of fact until all of the contractual issues that are in the record and are in the brief as to the SHS Wilcox agreement were resolved. But if that SHS Wilcox agreement is deemed to be in effect, and I suggest that the court can make that finding, much like Justice Cohen did when he found, unlike Kings County, that the TKE SHS agreement was in effect. But if that SHS Wilcox agreement is deemed in effect, there's no doubt that there is an additional insured under the USIC policy, and there's no doubt, at least we argue, that that policy is then primary to the HDI defense obligation.
Okay, thank you.
Thank you.
People versus Darrell Thompson.
Good afternoon, Your Honors. May it please the Court. Center for Appellate Litigation by Marika Mies for Appellant Darrell T. This court should reverse the lower court's decision because the preponderance of reliable, objective evidence does not support that Mr. T had a dangerous mental disorder at the time of the hearing. And his subsequently going off medication, defeating the hospital's attempt to treat him and medicate him over his objection, and his ultimate release from secured confinement to the community further confirms that. Viewing this record objectively, there is almost no incidence of violence in the 9 years that Darrell T was in OMH confinement from 2015 until the hearing was held in this case. There were 2 incidents in 2016, and in both of those, he was defending himself. There are also almost no incidents of him having psychosis in the entire record, including from 1994, before the underlying criminal case in this matter. The supposed manic behavior that the court and that the people's experts relied on were for things that Darrell T had a right to do, like exercise and make calls to the Justice Center and advocate for himself legally. Those are not things that can be objectively viewed as showing any dangerousness. His being moody or self-advocating or even being loud and difficult simply don't make out a dangerous mental disorder.
Did you say simply being difficult?
Yes. Being difficult to manage by the hospital and them preferring that he be on medication is not tantamount to having a dangerous mental disorder.
Threats of violence against hospital staff falls into that category?
I think there are, if you look at the record objectively, there are very few, if any, threats against hospital staff, especially at OMH. In the pre-acquittal records from 1994 to 2013, there are a few incidents of supposed threats, but none of them are ever acted upon. And all of his self-reported acts of violence or suicidal acts, none of those have actually been corroborated. And in fact, due to his established malingering, where his own long-term treating psychiatrist, when he was at OMH for 9 years, said that he could act out the symptoms of any number of mental illnesses, don't support that he ever was actually violent. So it can't just be a notation in a record that a threat was made. The standard for dangerous mental disorder has to show that he's actually a threat to himself or to others.
So you're saying that there were no actual acts of violence?
I'm saying that there are minimal, if any. And in his entire 9 years in OMH, there are 2, both in the spring of 2016, and both of which was when he was defending himself, and that was admitted to by the people's own experts. In the pre-acquittal records, there is also no actual corroborated violence. There are some times where he would come into a hospital when he was seeking treatment, and he would report either suicidal thoughts or having hurt somebody, but none of those things were actually corroborated. And putting that in context, as the court must, with his established malingering, those cannot serve as the basis to find him actually violent. And in any event, those would have been very distant from the time of the new initial hearing ordered by this court, which was in 2021. So whether in 2012 he threatened a doctor upon release but didn't act on that cannot be used to find him actually to have had a dangerous mental disorder many, many years later. So importantly, if you look at the court's decision below, and the reason that I'm asking this court to consider the subsequent release, even though that happened after the new initial hearing, is because the court below based its decision largely on the people's experts, who said that if Mr. T were to go off medication, he would decompensate, he would become violent, and therefore he must remain track 1 and he should stay committed.
Does the record show that he was compliant, or does the record show that your client went off his medication on a regular basis?
He did at various times.
Which one?
Which record or which
No.
one?
So I asked you a 2-part question.
Yes.
Does the record show that he was compliant, or does the record show that he regularly went off his medication?
So I think there's both. There's a history of having gone off his medication at various points prior to his admission to OMH. When he's in OMH, once there had been a treatment over objection order in 2016, he's consistently complied with medication. But what I'm saying is that subsequently he went off medication within months of the court's decision here. And then he was released to the community by judges finding him not to be dangerous at all. And what I'm saying is the reason that this court should consider that, even though it happened after the new initial hearing, is because the court had relied on the fact that if he went off medication, he would be dangerous. And the opposite.
Counsel, how do we deal with the fact, I believe it was 4 doctors, right?
Yes.
That defendant had indicated he was not, he didn't have a mental illness, he didn't need medication. How do we deal with that?
Well, we conceded that on the record he could be established as having a history of a mental illness, but that is not determinative because you need be both you have to be both mentally
and the
ill.
history of non-compliance with medication, the history of drug use.
Well, he had a history of actually compliance with medication for 9 years in OMH, or nearly 9 years. But what I'm saying is that once he went off medication, he got released to the community directly from secure confinement.
We have to deal with what the court had before it at that time, not after. So that's what we're looking at.
Yes, and I'm suggesting the reason you have to look at what happened afterwards was because Justice Fabrizio below, he relied on the people's experts, and their prediction was that if he were to go off medication, he would be dangerous. That was proven false. Therefore,
Well, you're
this
proving
court...
that false by after the fact, right? I mean, hindsight's 20/20 vision. I mean, the judge at that time, he has the evidence, as my colleague pointed out, has all the evidence before him, And he wrote a very thorough decision. I mean, it wasn't like 2 pages. It was like 30-page decision.
I understand,
So
but
he thought
if you break,
much about it.
yes, Your Honor, but if you break that decision down and look at what he was actually, the actual objective evidence, it is disproven that he was ever violent. You can't take isolated incidents from 20 years before and call a person historically violent.
Okay, thank you.
May it please the court, Noah Shemoy for the people. The Honorable Ralph Fabrizio was correct in July 2021 when he found by preponderance of the evidence that Daryl T. suffered from a dangerous mental disorder that required treatment in a secured psychiatric hospital.
I mean, he had the doctors in front of him. They're testifying, right? They're under cross-examination too, I would assume.
Exactly, and as the trier of fact, Justice Fabrizio's credibility determinations deserve great deference. He credited the people's witnesses, Dr. Hicks and Dr. Zhu, but he also credited the defense witness, Dr. Green. And based on the testimony of those 3 witnesses, he came to the conclusion that Daryl T. suffered from a dangerous mental disorder. Importantly, he discredited expressly the only defense witnesses, Dr. Berenson, who is at this point the only evidence that the defense is really relying on that was before that court, and made the same arguments that the defense is now making now based on subsequent activities and things that are not within the record. To clarify, everything the defense is arguing are materials that were brought up in the reply for the first time, which is improper, but also reflect matters that are being litigated in Monroe County, and that respondent does not have the actual records of those transcripts. Respondent has not seen them. Well, I have not seen them in preparation for this because this was brought up on reply, and this court has not seen them. So it's based exclusively on the decision of a judge in another county who discredited people's witnesses there and credited defense witnesses there. And there are any number of reasons why that outcome could have happened. And all of them are speculative for purposes of evaluation by this court.
We don't have that. I mean, that you can't rely on what happened after the fact I mean, hindsight's always 20/20 vision, right? I mean.
Correct. But it's important to recognize that at the time of this proceeding, the defendant was decompensating actively. And that was a major factor because obviously looking at dangerous is looking at current dangerousness.
Did he state that he was only taking medication so that he could eventually be released?
Yes, Your Honor. In fact, that was a major factor that all of the doctors, including Dr. Green, looked at in considering what the proper outcome is. Now, having said that, Dr. Green's disagreement, and the only reason why a defense witness even found, a credited defense witness found he did not suffer from dangerous mental disorder, and that was Dr. Green, was because she felt that he had expressed insight to his substance abuse, although even then he refused to acknowledge that he had a mental illness. He believed he only had a mood disorder and only wanted treatment for the same. And his few years of compliance with medical treatment. But I believe that People v. George L. from the Court of Appeals addresses this situation perfectly, which is the Court of Appeals said that the term currently suffers from a mental illness should not be defined strictly because once an individual is committed, they ordinarily pose little current risk to themselves or others, as in for physical violence, as my adversary pointed out, when they're receiving their medication, are forced to comply with the treatment plan, and would try to be on good behavior to ensure their release, which are all the exact arguments that are being presented here.
Counsel, how many times was the plaintiff committed?
How many acts of violence?
I mean, not the plaintiff, excuse me.
Well, I will start.
The defendant.
Yes. I will start from March 2013.
Just give me a number.
Going back.
If you
I could list them for you, but a number would be at least 15 to 20. But starting March 2013 with the robbery, you have the spring 2015 crime that was not prosecuted as such when he threatened to murder his attorney, chased them into a secure staff area, and had to be forcibly restrained and, in fact, assaulted by staff, as was later found out. The May 2015 physical attack on a medical assistant at Mid-Hudson, where the source of that information is actually his own defense attorney at the time.
I don't want you to run all your time.
Oh, yes.
What's the most recent hospitalization?
The most recent violent acts was simply violent threats and behavior and veiled threats that continued through to 2017 when the treatment over objection and he was forced to comply with medication. From that date, what we have is proof that he threatened to fight another patient after spring 2020. That required intervention, and that is the key to secured facilities, is that the intervention is what prevents them from actually acting in the violent way that they were. And he did, after spring 2020, threaten staff, but he didn't physically attack any of the staff. And in fact, just before the hearing, because of his continued, if I may finish my one second, because of his continued belligerence and threats and violence, he was actually moved to a different part of the facility.
Okay, thank you.
Thank you. Please affirm.
The subsequent release to the community and the order of conditions are actually part of this record because they were uploaded as exhibits, and the people were participants in the hearing that led to his ultimate release. So these were arguments that they were aware of, and they're not new arguments that were raised for the first time in reply. In terms of the actual violence, there are 2 incidents alone in 2016, both of which he was defending himself. That's it in a 9-year record. And the court had this hearing in 2021, so those were still 5 years before, and he had been consistently medication compliant. So even if you ignore everything that happened subsequently, which proves, in fact, that the doctors on which Justice Fabrizio relied were wrong, because their prediction that if he went off medication, he would be decompensated and become violent was wrong. Instead, he was released to the community and is thriving and working without incident.
I guess the way I'm looking at it is, was the evidence there that allowed Judge Fabrizio to find that by preponderance of the evidence that it was established that, there was a track 1 determination that should be a track 1 determination?
No, Your Honor, because the evidence on which he based it was the people's experts, but the people's experts admitted on cross-examination that, for example, these 15 supposed acts of violence in the pre-committal records were not true. He admitted that they were self-reported, uncorroborated, that they were likely faked. And so if you're relying on evidence that isn't objective and reliable, it cannot meet the preponderance of the evidence standard. And also, when they are distant from the actual hearing, the George L. standard requires that you look at what his dangerousness was at the time of the initial hearing. He had been consistently medication compliant for over 5 years. And whether his motivation was to get released, as he ultimately did or not, it matters to the analysis that you have to look at the actual record. And at best, the people can point to threats, but threats are not violence, and they do not make out a dangerous mental disorder as required by Court of Appeals precedent and the statute.
Thank you.
Thank you.
Hall versus Middleton.
Good afternoon, Your Honors. May it please the Court. My name is Barrett Cardenas, and I represent the appellants in this matter. This is a shareholder derivative suit where the core issue concerns property rights, namely whether a patented invention is owned by its inventor or it's owned by a company that is formed by the inventor. The lower court erred when it determined that the company was the owner of the patented invention when the evidence introduced at trial failed to show this result. Under the law, there is a presumption that a patented invention is owned by its inventors. This presumption was not rebutted. There are only certain situations where a patented invention would be owned by a corporation formed by the inventor. This can only really happen in 2 scenarios.
How is this marketed?
Sorry?
How is this marketed?
How is this marketed?
The invention, how is it marketed?
Oh, the invention itself was, from what I understand, it was marketed, but it was marketed in the sense of just through a patent marking and through showing that the company, I'm sorry, not the company, but basically showing that, just to show to the world that the company, that the invention itself was going to be patented, and if anyone was going to usurp that patent, that they would have to that there would be a patent issue.
But as the individual's patent?
Sorry?
As the individual's patent?
Has
Mr., I'm sorry.
Yeah.
As Mr. Hall's patent? As Mr. Hall's invention?
It's not Mr. Hall's invention. It was Mr. Middleton's invention.
I'm sorry.
And yes,
the name's backwards.
Yeah, Mr. Middleton was the plaintiff. Mr. Hall was the plaintiff. Mr. Middleton conceived, created, and put into practice the invention well before the corporation was even formed.
Did he ever
the
make...
patents did not come into? Yes.
Sorry. Keep going. I just was wondering, did he ever make representations that the company owned the patents and not him?
I would argue that he didn't. There were certain representations that were made where he referred to we in regard to who has the patents. However, I would argue that when he was referring to we, he was referring to himself. And he was also referring to his co-inventor, Mr. Boghossian. There was also another inventor involved. Okay, there were multiple patent applications that were filed. All the patent applications included Mr. Middleton and Mr. Boghossian. My understanding is that there was one patent application that mistakenly included the corporation, and that was corrected. The issue is that patent application in of itself does not provide ownership in the company. In reality, the only thing that can provide ownership in the company is whether there's an assignment to the company with compensation. That didn't occur, and there was no evidence to show that. Alternatively,
I'm sorry, but in order to agree with your position ultimately, would we have to reject Justice Schechter's credibility findings?
I would say that in regard to what Justice Schechter referred to, I don't believe that Mr. Middleton's credibility should even come into play. As I said, in order for the patent to be owned by the company, the evidence must show that there's been an assignment and that through that assignment, there's also been compensation. That wasn't provided at trial. Alternatively, you would need to show that the company, that the inventor was an employee of the company at the time that the invention itself was created, that he received compensation and that he used the company's resources. That also is not the case. And it's impossible because the invention itself was created before the company was even formed. Therefore, the entire decision should be thrown out.
So the marketing did not represent that the company owned the patent or would own the patent?
No. And
I'm sorry.
I believe...
No, it did not show that?
I believe that the marketing itself is a bit confusing because the whole point of that marketing was to show to the world that there was a patent, not that Veritasium Inc. was the owner of the patent. Nevertheless, even if that marketing, even if that marketing came out to say that, Veritasium Inc. Had some kind of ownership interest, that ownership interest, even if it showed that Veritasium Inc. had an ownership interest, that ownership interest couldn't even come into play absent that transfer from Mr. Middleton by an assignment. That never happened. Mr. Middleton never received compensation.
Thank you.
Thank you.
Good afternoon. My name is John Grabowski, and I represent plaintiff respondent Charles Hall in this case. And as we've heard, appellant's entire appeal is based on the erroneous assertion that Veritasium Inc. never had ownership of the patents and patent applications at issue here. This is contradicted by a mountain of evidence. And so there's no mistake. I'd like to briefly walk through this evidence, both in terms of what was filed with the U.S. Patent Office and the international patent offices, and what was told to investors in Veritasium Inc. If we look at the May 5th, 2015 PCT request that was part of the U.S. and international patent applications, it lists Veritasium Inc. as the applicant. That's at record site 777. Elsewhere in the patent file, you'll see that Veritasium Inc. is listed as an applicant, of these patents, record site 1008, record site 943, record site 1099. If you look at the power of attorney filed with the U.S. Patent Office dated November 8th, 2016, it states that Veritasium Inc. is, quote, an assignee or person to whom the inventor is under an obligation to assign. That's at record site 284. If you look at the patent application published by the USPTO on June 29th, 2017, it listed Veritasium Inc. as an applicant. That's at record site 1055. If you look at the power of attorney filed with the USPTO, signed by Mr. Middleton himself on April 10th, 2019, it lists Veritasium Inc. as the assignee and states that, quote, the individual whose signature and title is supplied below is authorized to act on behalf of the assignee. Now, what happened here is that the patents and patent applications were owned by Veritasium Inc. Mr. Middleton assigned them out of the U.S. Patent Office and to himself. It's not as if Mr. Middleton never assigned them to Veritasium Inc. It's the other way around. It's he assigned them to himself, and that's what's so intentional and egregious here. Now, even if we were to suspend disbelief and ignore everything that's been filed in the Patent Office, let's look at what was disclosed to the investors in the company. And as the trial court pointed out, if you look at the most express example of this is from the Q4 report in 2015, and that's available at record site 1258. And that report, for about 4 or 5 pages, it talks about the patents and how important they are to the company. It says, quote, Veritasium has a filing date, and refers to Veritasium, quote, Veritasium patent applications. It touts the benefits of Veritasium being the first to file. It also has a couple pages where it performs this discounted cash flow analysis and sets forth that the value of the Veritasium patents could be so much more than that of Goldman Sachs or the Bank of America patents. And if Veritasium never owned the patents, why would you be touting this to shareholders? What's the point?
Counsel, I like to go to another point, about the punitive damages.
Okay.
Because appellant also is saying that the award was erroneous. And is such an award proper when there's no compensatory damages?
Yes, Your Honor, it is, and we cite a case for that. It's proper. Punitive damages can be awarded if you're able to obtain equitable relief, and that was the case here. We only sought equitable relief given the fact that there was such a misappropriation of corporate opportunity, corporate assets. And I can find that case is we cite as the IHP Corp case. It's a First Department case, which basically holds you can have punitive damages with equitable relief so long as you meet the punitive damages threshold, which requires intentional, deliberate, morally culpable conduct, which we have here because there was a complete, intentional, and deliberate transfer of the assets out of the company to Mr. Middleton himself.
Is an intentional tort enough to trigger punitive damages, or does there need to be something more?
There needs to be more, and here we have that more. The behavior here, there was no doubt it was intentional. It was in conjunction with Mr. Middleton's patent lawyer. It happened one day before the deposition in this case, so he knew what he was doing. There's also, the circumstances are that there was also an SEC enforcement action against him that greatly depressed the value of the company. There was a $1 million penalty put into place against him. And as I said in my opening statement at the trial, that the pattern and behavior just illustrated to the court that Mr. Middleton thought he was above the law, that he could do whatever he wanted, and the behavior was intentional, flagrant, and it had that same morally culpable component that is required to award punitive damages. And that was decided by Justice Scheck. There was a fact finding, and it was based in large part on Mr. Middleton's incredible and evasive answers at trial and at deposition.
Oh, one question. Oh, don't go away.
Okay.
So, counsel, with respect to the 2019 SEC consent judgment, which awarded, not awarded, which required Mr. Middleton to pay $9.4 million in disgorgement, interest, and civil penalties, can that be characterized? Can the $1 million punitive damages be characterized as double dipping, as alleged by your adversary?
The $1 million penalty went to the SEC. It was part of their judgment. I wouldn't characterize it as double dipping because
I'm asking you, it's a peculiar.
okay, yeah.
It's a peculiar.
I don't think that the two are related in the sense that the SEC action and award is part of the facts of what went on with Veritasium Inc. and Mr. Middleton. But there's no monetary relief coming to
This is
the
going to
company
the company.
because of it,
Is it?
or the shareholders.
Well, this punitive damages is going to the company, no?
The punitive damages is going from Mr. Middleton back to the company.
Right.
$1 million that went to the SEC went to
yeah,
the SEC.
right.
So I guess that was my point. That's
Okay.
what I'm trying to clarify.
Thank you.
First, I would like to talk about the SEC consent judgment. That was a consent judgment. There was no wrongdoing on behalf of determined on behalf of my client. That was agreed to by the parties, and my client paid a penalty for that. There should not be a situation where he's required to pay double, in the sense of paying an additional punitive damage award as a result of that. Second, the invention, the patented invention, was owned by my client. It was always owned by him. There were prior patent applications that only included Mr. Middleton and his co-inventor, Mr. Boghossian. There was an issue where on one of the patent applications, mistakenly Veritasium Inc. was placed on it. But that wasn't a situation where there was an assignment of the patent invention from Mr. Middleton and his co-inventor to Veritasium Inc. In addition, I would also like to note the fact that on those patent applications, they didn't just include Veritasium Inc. It also included Mr. Middleton and Mr. Boghossian. So they've never intended to transfer their patented invention to Veritasium Inc. Thank you.
Thank you.
Well, I have a question. What is your response to counsel's argument that punitive damages are appropriate in this instance, in light of the finding of the breach of fiduciary duty?
Yeah, as I believe, as I said in my brief, I don't believe that punitive damages in this case are appropriate.
Why?
Because there were two things. One, there were no damages as a result of this derivative claim, even if we were to come to the conclusion that the company should have owned the patents. There was no damage to the company. The patents themselves had not generated any income at the time that the patents were issued. As such, the company did not lose anything from not owning the patents. Also, as a result of that, there shouldn't be any punitive damages as well. It was my client's invention. It belonged to him, and now he's being forced to transfer his interest in something that he created to a company that didn't even exist at the time that he created the invention.
What do you say to the question then? This is cryptocurrency. This is like the frontier. There's no regulation. There's no legislation. The punitive damages here, if you read Justice Schechter's decision at the end, basically said it's to keep everybody honest in a very unregulated industry or in an unregulated area. So what do you say to that? That's why it came down, right?
I mean, the cryptocurrency is a separate issue. The purpose of this company was to be a software development company that developed a peer-to-peer network to be able to transfer crypto through swaps on the blockchain network. It had nothing to do with the actual cryptocurrency that my client developed. The company itself is a software company. The software was developed. The company was supposed to have a royalty-free right to use the invention. And there are other situations where this has happened in the past. If you look at other companies like Google, there were two students that created the search algorithm that Google uses. That search algorithm.
I don't think
patents were
I don't think
owned
crypto.
by Google-
I'm
were
not so
owned by
sure you.
Stanford. Sorry.
I don't know if you can equate
I don't
crypto versus to Google, but anyway, Justice Gonzalez has a question.
Counsel, does Mr. Middleton remain the majority investor
Yes,
in
he
the
does.
company?
Yes.
So if there's a $1 million penalty by way of punitive damages payable to the company, is that money simply invested in the company in which he has the majority investment? I mean, is it a circular? Is it a
It's
circular
circular,
situation?
He doesn't have the money. That's the problem. I think that's the biggest problem is he doesn't have $1 million to put into the company. But if he had, I guess if he had $1 million and it was put into the company, the majority of it would still belong to him because he's the majority shareholder.
Thank you.
Thank you.
Thank you.
Patterson Belknap versus Marcus. Okay.
Thank you, Your Honor, and good afternoon. David Marcus, on behalf of Marcus and Cinelli, and on behalf of myself as well. In 2009, Patterson Belknap had represented Barbara Stewart for a couple of years, and they withdrew as counsel. We had stepped in and agreed to take over.
It all comes down to the sale of the ring, right? I mean, the sale, one of the big portions about this is the proceeds of the sale of the ring, and that the fact that my notes indicate that the firm at the time got the restraining notice about your client, I forget her name, Ms. Stewart's debt that she owed to the firm, right?
They claimed that they had gotten a restraining notice and served it on her.
And you did not get a copy of that? You did not have notice of that restraining notice?
They claim that they sent me a copy, an email with an attachment.
Yeah.
But that is an attachment 2.5 years prior to that time.
You had no idea there was a restraining notice on Ms. Stewart?
I was not aware of the terms of any restraining notice or anything that would have.
And your client, Ms. Stewart, never told you that she had a restraining notice?
I don't think she understood what was on
okay.
it. I don't know. Maybe she did or she
Counsel,
didn't. No,
I
she
have
didn't.
to say, these are really yes or no questions. Were you aware that there was a restraining order on the assets of your client at the point where you decided to facilitate the auction of a diamond ring?
No, I was not aware that there.
Your firm, I'm sorry, not you personally.
Well, yeah.
A big
It was
difference.
said to my firm. I know.
Your firm. Uh-huh. Was your firm aware, sir?
I'm sorry?
Was your firm aware? Did it receive an email? Did it receive an emailed copy of the restraining order? Or are you denying that now?
I'm not denying that we received it.
So
I
that's a
don't
yes.
know. I'm not saying.
No.
don't-
Mira, it's one or the
don't-
other.
yeah. I just.
Did your firm receive a copy of the restraining order by email?
I do not recall, as we sit here now, and that's the best answer. I don't recall receiving that. It was years before, and even if I had received it, I don't think it matters because it's not something that would have been effective. It wasn't served on us, and we had a security interest in the proceeds.
Well, I don't have, I'm not, you had a security, and you have to get your bills paid. I mean, that's the way I'm looking at it, this case is teed up as a 3211. You're moving the dismissed on the
Right.
pleadings, right?
Right.
And you assume the allegations are true to be true. I mean, it sounds like there's enough there to keep it going, right? Until discovery happens, because once discovery happens, this may be ripe for summary judgment, but on the pleading stage, yeah.
Judge, I think that, Your Honor, I think they knew about the ring.
When you're saying
and its
they,
sale.
you gotta-
Patterson
you
Belknap
gotta
knew about
identify-
the ring and its sale
You
for
got to
years.
identify the pronoun. They knew. Who's the they? You mean Patterson Belknap knew about
Patterson
the ring?
Belknap.
Yeah, they could have known about the ring, but they didn't know she was going to dispose of it.
Oh,
and sell it.
they knew that she had it. They knew it in 2000.
Well, how do you have in the evidence here in your motion that actually demonstrated that?
I'm sorry?
In your motion to dismiss the 3211, I don't recall seeing documentary evidence indicating that Patterson Belknap knew that she had they had to know she had the ring and that she was going to sell that ring.
They were provided in 2018. We had sued the jewelry case against her daughter-in-law. Michelle, her daughter-in-law, counterclaimed, saying that she had sold jewelry and she being Barbara Stewart. I'm sorry.
Yeah, you got to identify.
Had sold jewelry, and then shortly thereafter, they submitted a list of all the jewelry that Barbara Stewart had, $5.3 million of jewelry that she had in her possession. This was 2020, including the ring, the diamond ring. Patterson Belknap was getting they were getting contemporaneous notices from the court of every pleading, every document that was filed in that case, and they were more than on notice. We were also talking to them.
How about the fact that there was some sort of arrangement where she was paying you ahead of time for fees that weren't even accrued yet? I thought I read something in my notes that she had paid you ahead of time, like without you incurring any legal fees. She paid you some money. So did I read that wrong?
No, she paid an advance retainer to us.
Oh, okay.
But that was refundable. That was only taken as billed, and that was an advance. Right. That was an advance retainer or a security retainer.
Right. Thank you.
All right.
May it please the court, Aaron Adolph on behalf of defendant appellant Brian Cinelli. As the court has already identified, this is a 3211 motion. And so we turn to the four corners of the pleadings, and Mr. Cinelli's name appears one time. There are no facts alleged against Mr. Cinelli. And it took getting through the first round of briefing in this appeal before.
Did you raise that argument before Supreme Court below?
Your Honor, we raised certainly the sufficiency of the pleadings argument.
But did you tell the court there's only one allegation against me and it should be tossed?
As we sit here, my involvement in this case came on a little bit later, Your Honor.
Me too.
I agree. Suffice to say, though, if the court's responsibility on a 3211 motion is to interrogate the pleadings to see if there has been framed out any claim.
Yes, but your argument is different now. On appeal, you're saying now you're taking a different tack. You're zooming in and focusing on the fact that there's only one allegation against my client, and that's not enough. That's not exactly what you said to Supreme Court. You're saying that the whole four corners was no good, right? So, the general versus the specific, right?
Well, and forgive me if I'm wrong
because
about
I
this,
don't know how the court would have handled that if you made that specific argument. I don't know if the court would have, focused on that and made a rendered decision.
Following the court's lead, there are some real issues with the court's decision insofar as defendants are all, I think the words used in some of the cases that we've cited, were clumped together. That nothing was disaggregated out. Actions that were attributed to M&C were subsequently attributed both to Mr. Marcus and to Mr. Cinelli, where those are frankly not the allegations at all. Plaintiffs have, as we've already pointed out, made one allegation against Mr. Cinelli, but facially as to all defendants.
Well, if you had made that argument about Mr. Cinelli, your client, maybe you would have gotten a motion to amend the complaint, and there would have been more allegations. I don't know. I mean, that's what I'm saying. If you don't make one move, It's like chess. You don't make a move, the other person's not gonna make a move. They're only gonna move, they're only gonna counter move once you make your move. And by not saying anything, and now you're raising and saying, oh, by the way, there was only one allegation, you kind of sandbagged them at that point, like, well, okay, no, okay. Because you know what's gonna happen after this is they're gonna make a motion to amend the complaint now that you raised it, right?
Well, Your Honor, if they were to do that,
Yeah.
I would suggest that they have already revealed their theory of the case as it goes to Mr. Cinelli.
I don't
And
know.
that is that
I
the
put that
court.
media away a long time ago. I don't know what they're gonna do next.
Well, what they've said is, and the basis for their entire claim against Mr. Cinelli is that every reasonable inference, including that, fill in every blank. This obliterates the requirement that a person plead with particularity. It obliterates the requirement that you provide some basis for veil
problem with
piercing.
the court's decision that, I mean, the court said that plaintiffs should be able to conduct a discovery to see if defendants use their status as lawyers to help hide the money of a client so that they could get paid themselves as well while knowing that a restraining order was in effect. That's pretty serious language.
I understand that that's serious language. Again, the problem is that that's not what was pled. It's not their conduct as lawyers. There's zero allegations as to Mr. Cinelli. There is even no specific allegations against Mr. Marcus. It's to the firm. They talk about Marcus and Cinelli being able to draw its fees. And now the theory is that there is a reasonable inference that should be applied where there's zero verbiage, but a reasonable inference. And this is a very dangerous case, Your Honors. Accepting the plaintiff's position about how the DCL should be interpreted would result in a scenario where any unsatisfied judgment for any defense firm whatsoever subjects every partner to potential personal liability, even if they had nothing to do with the underlying facts in the case. Right here, we're
How do you
talking.
reconcile? Yeah, Judge Owen is asking, this is not preserved, so how do we get around that? I wasn't really sure I got an answer when it was asked earlier.
The sufficiency of the allegations on the face of the pleadings. Yes.
Look, I think your doomsday scenario is not quite there yet. Okay, I mean, it all depends on, like you just said, depends on if there's a nexus between whatever happened to the partner. If there's no nexus, partner gets walk away. I mean, the firm walks away, right? Once there's an established nexus, you're kind of in a problem. You got a little bit of a problem. So we're still a little bit far from that. I mean, the doomsday is not just yet there, right? There's a lot to show before any firm or any partner of a law firm is going to be on the hook for anything.
And I understand the court's position on that. I would just suggest that the cost, the time and expense associated with litigation.
You know how many litigation books that we have filling the rafters in this court in terms of cost and time? I mean, please. Okay, thank you. You have rebuttal time.
Good afternoon, Your Honors. David Kleban for Patterson, Belknap, Webb, and Tyler, which is the respondent in this appeal from the denial of a motion to dismiss. To accept Mr. Marcus's arguments on this motion to dismiss would require the court to make factual determinations before there's ever been discovery. He talks about what Patterson knew, when it knew it, what it should have known. All of these things are items that just can't possibly.
Or what did they know, right? Not only what you know, but what did they know?
Or what did they know? We have in the complaint.
You, of course, know what you know. We don't know what they know.
And one thing we know is that we sent Mr. Marcus a copy of the restraining notice that his client was subject to, and that after we did that, he helped her sell a diamond ring to Sotheby's for $2.4 million.
When you say Mr. Marcus, do you mean him directly?
Yes, the email was sent to Mr. Marcus personally. That's right. It's a two-person law firm. Mr. Marcus was one of the partners. Mr. Cinelli was the other. I would like to address a couple of the arguments made on behalf of Mr. Cinelli. So first of all, it's not just that they didn't preserve this argument. They moved together. They moved jointly as the defendants for a motion to dismiss. They did not distinguish Mr. Cinelli at all. Okay, so that's one thing. The other thing is that even on the merits, these arguments are incorrect. We do state a claim against Mr. Cinelli. This is not a common law fraud claim, where which are the kinds of cases Mr. Cinelli cites. This is a statutory cause of action where a creditor can recover monies that are inappropriately sent to other parties. Mr. Cinelli was a partner of a two-person pass-through entity. Okay, a law firm distributes revenues to its partners. Okay, we can take judicial notice of that. That's an inference we're allowed to draw at the pleading stage. This law firm is now disbanded. So if monies were given to Mr. Cinelli as a result of these ill-gotten revenues, then that's our only remedy, is to go after Mr. Cinelli. And we cannot know without the benefit of discovery whether that's true. I think we'll be able to show a nexus between these events, the fraudulent conveyances that we allege.
Even before you get to that down the road, you still have to show that they knew about the restraining notices, they knew about this sale. I mean, that, you know, it's the little steps to get down to where you want to get to. I mean, that's your ultimate thing. Like, disgorgement is your ultimate relief, right?
There's various
You
elements.
got a lot of hurdles to get there before you say pay up.
Well, and we're confident we'll be able to meet the elements of the causes of action we've pleaded. We're confident that we have pleaded those elements.
How do you respond to your friend's, what I'll say, policy point that there's a danger here in exposing lawyers and law firms to this type of liability? Today, you're on the plaintiff's side of the V on this. Tomorrow, you could be on the defendant's side of the V on a case like this. How do you respond to that concern that we're, you know, exposing the law firms and lawyers to untoward and unpredictable liability under the debtor-creditor law?
Well, I don't think that there is such a doomsday scenario, Your Honor. I mean, if indeed a law firm is the recipient of a fraudulent conveyance that is then disgorged, either the law firm should pay it pursuant to a judgment issued according to those findings. If that law firm is no longer in existence, as is the case here, and those monies have been distributed to the various partners, then I don't think there's anything wrong. If the plaintiff can prove up the fact that those monies went to those people, I think that that's just a classic case of a subsequent transferee in a fraudulent conveyance. So it can get complicated, theoretically can get very complicated as a factual matter if you've got a big law firm. Here you've got two partners. Here you've got two.
So is that what sort of takes the sting out of the pleading, the defendants lumping them together, that it was only a two-person law firm? Because your friends both pointed out that on a pleading motion, there still was no sort of segregation or separation of the various defendants here for pleading purposes.
And that would be a fair point if I were pleading a tort claim against Mr. Cinelli, but I'm not. I'm pleading that he was the recipient of a fraudulent conveyance, and there's a statutory cause of action. Even if somebody is an innocent, if they have an innocent state of mind, that can supply the basis for a fraudulent conveyance claim, a constructive fraudulent conveyance claim. That brings me.
Question.
Pardon me.
With respect to your allegations pursuant to DCL 273 and 274, 273 being that the person who made the conveyance will thereby be rendered insolvent, and 274 where it says the conveyance will leave the person making the conveyance with an unreasonably small amount of capital. Are you still pursuing causes of action under those two statutes, or are you withdrawing?
They're not withdrawn, Your Honor. They're in the complaint.
Because on the one hand, at one point, you said that Barbara Stewart ran the risk of becoming insolvent, and then after that, you said, nah, she has money.
Well, I think we need to investigate the facts more, and I think that's what discovery is for. I think that the 273 and 274 claims are of relatively minimal importance in this case, given the presence of the 273-A case. But at this point, I think we're allowed to plead in the alternative. I'm sorry, I have one critical point to make that'll take me 60 seconds. In his reply brief, Mr. Cinelli raises for the first time an argument that the transferee's intent is necessary to prove under a 276 claim. And he cites cases from the SDNY bankruptcy court, which have been repudiated in later decisions of the same court. I want to make sure that I read those because they were in his reply brief. So
We got it. If it's in the reply brief, we got it.
no, they're in his reply brief.
No, but you made the note of, we'll take a look.
It's bad law. Okay.
Okay, thank you. Got it.
Your Honors, you asked about notice and knowledge, but the notice and knowledge also of the plaintiff is critical here.
Yeah, no question.
It's critical, and there's documentary.
Well, it'd be interesting at discovery what she's going to say, what Ms. Stewart will say during a deposition, right?
Well, she's not a party in this action. They have not sued her. They have not brought her in.
She can't be subpoenaed. I'm asking.
They could. I imagine she's in Switzerland. I don't know if she comes back to New York or what she does. But here's the thing. They were saying they were sending the restraining notice in 2021 before they sued this case, saying, "Oh, by the way, we have a restraining notice. We have a restraining notice." We got it. We got it then. But they were letting us continue to work these cases for another year, 2 years. We were working these cases while they were letting us do the work while they were well aware of all the facts that they sued in their complaint.
They can't interfere with your attorney-client relationship. What right do they have to tell you to stop representing her? I mean, you served her with a restraining notice. Doesn't mean that you can't. Doesn't mean that gives them the authority to say, "Oh, by the way, you cannot represent Ms. Stewart." I mean,
no, it's not that. But they could have come in and said, "We repudiate what you're doing. Don't keep working," because they wanted us to do the work because they were levying on all the proceeds. Okay. Everything that we did was legal, bona fide legal services. Everything was bona fide, and they knew it.
Right, like I said, it might be right for summary judgment then, if that's the position you're holding.
Well, it's undisputed. It's undisputed that it's all, and they have an obligation to plead specifics.
Well, that's what
fair consideration.
If it's truly undisputed, you got a ripe 3212 motion. Once you filed your answer, you make your 32 motion at the same time. I mean, if it's undisputed, you're good to go, right? I mean, I only have in front of me a 3211. I know
right.
much. That's my training. I only can look at what's in front of me.
Yes,
I don't
yes,
go,
and
I've been taught very well. Stay within your bounds. Right?
I appreciate that, Your Honor, but there is pleading requirements here, and they have to plead fair consideration, insolvency, dominion and control with particularity, and some fraudulent scheme. Where is a fraudulent scheme when they're watching us do work for 13 years? That's all we did. We worked for her. We talked to them. We invited them to join and litigate with us. And they didn't want to do the work, but they wanted to get the benefits from it.
Okay.
Your Honor, if I could just, one last point, in Casaforte versus, I believe it's Portavusi, and I believe Your Honor was one of the signatories.
I don't remember. I had the dinner last night.
Yeah, it was 2023.
Yeah.
Or it held that where the documentary evidence establishes that plaintiff received benefits from the transaction, it challenges. A motion to dismiss should be granted.
Okay.
And citing the Bernard case.
I got it, counsel. We got it. It's fine. Yeah. You don't have to cite the cases. Thank you.
Thank you. Thank you.
Very briefly, Your Honor. Sure. The suggestion that we need discovery on the status of Barbara Stewart's solvency or lack thereof is, putting it as courteously as I can, misleading. That issue has been litigated for years by plaintiff. They've taken depositions. They, to this point, after motion practice, provided thousands of pages of Ms. Stewart's financial information. And so to stand here and to file a pleading in the case, representing insolvency when they have information that they are misrepresenting to the court it's an abuse, frankly, is how I view it. And to the other point that the court made about Patterson not having the right to interfere with an attorney-client relationship. That ignores the other half of the DCL, which says that a insolvent or judgment creditor in this case, debtor in this case, cannot assume any further obligations. It's not just transferring property, it's assume obligations. The judgment creditor has the right to intervene where the judgment debtor is assuming further obligations. So they did have the right, and they waived them. They sat back and they watched. They levied on, even now. It's
You know,
in the
but I
court
think
filings.
you're traveling, that's, you know, when you're dealing with attorney-client relationships, it's a little bit more sticky than if you're assuming debt obligations, like going out buy a piece of buy property or buying your shares in a company, yeah, a little slightly different.
Your Honor, this case is fraught. I could not agree more.
Oh, that's an understatement.
Yeah, and I think that it does. I mean, I didn't use the term doomsday, but I really do believe that
Not a
this could have
doomsday.
far-reaching ramifications.
Not a doomsday yet.
Not yet. Again, the point is, though, that you have a scenario where they did have an avenue to intervene, and the DCL doesn't have a carve-out for attorney-client relations. That's not something that's in there. It's any obligation. It's very clear. So knowing, and they had testimony on this, and they have financial records from Stewart on this, and they put it in their pleadings and in other court filings that she was obligated to the extent of some $650,000, testified, oh, I didn't know it was that little, to Marcus and Cinelli. They were well aware that this work was going on, and they chose as a business decision not to do anything about it. They waived their rights they knew they had under the DCL to intervene.
Okay, got it. Thank you.
Your Honor.
Voram versus Hicks Voram. Okay.
Excuse me. Let me thank the court for allowing me to argue this non-enumerated appeal. I'm sorry it's getting on to 5 o'clock. I'll only take a few minutes. I'm actually staggered that our adversary didn't show up. They got notice under NICEF. They objected to the fact that we wanted to argue it. The only thing I could come up with this is a very difficult, in my judgment, decisions actually to justify in this case. It's a huge case. The husband is the CEO and the president of a multinational company with jurisdiction in 17 different places. $100 million was made last year in the business. He's the CEO. We listed a bunch of perks that he gets from the business, including houses in New York, in London, in the Netherlands. We've listed an airplane that the company owns that he gets to fly. Judge O'Neill Levy, coming from the matrimonial court so recently, there's probably nothing new in what I'm having to say, but there's enormous wealth on the husband's side. And frankly, the first part of the brief of my adversary is that these people both had the same, I'm trying to get it exactly. He basically said they both have the same comparable incomes. She was making $150,000 a year working for SMT, the husband's company. She was fired as soon as he filed his divorce action.
What do you-
Basically, yes.
Just touching on what we were working on, what do you think about Judge Katz saying you can come back if you find that there is an ownership interest that the husband has, that you can come back and ask for additional fees in order to pursue that?
So that's a good question. But Judge Katz, what he said is not the law. The law is that we have to be treated the same way as our adversary. Our adversary violated 237 of the domestic relations law by not setting forth how much he's been paid, by not setting forth how much he's owed by giving detail, as 237 requires. So he violated the law. And if he was paid on, as we must assume, he was paid regularly, we're entitled to be paid regularly. We don't have, we were owed, we got just under 20% of what our actual time was, and we got about 16% of what we asked for. We asked for $625,000, which was $484,000 of what we were owed, actual time expended. They placed no issue on any of our time records. They didn't attack it. They had nothing to say about our time records. I hope that answers your question, plus a little. I didn't mean to go on.
No.
But we were entitled to be paid. Our client has no money. There were 3 children. It's a 28-year marriage. He announced by filing a divorce, they had been separated for a while. There was an attempt at mediation. It failed very badly. And by the way, another reason my adversary may not have been here, and it's all laid out in our briefs, they misstated from the record. They included lots of material that's not in the record, and they challenged cases that said exactly the opposite of what they said. You needn't take any time, and it's all laid out in the brief. Is there any question? I want to read just from 2 cases, one from this court's decision in Wolf and Wolf against Wolf. Since exactly the same, the wife made an application for counsel fees. The husband had the money, which is not unusual. The court said, since defendant, the husband, has not disclosed his own fee arrangements, it may be presumed his obligations of payments are equal to or greater than those of the plaintiff. If this court follows that decision, and that was a First Department case, if it follows that, we should get the full amount of what we sought without any diminution. The second that I want to read is from the Tomasetti case, which is a decision, that was my case.
Yeah, the second department.
In the second department. It was my case in the second department. And the court said, and I think it's important for this court, I'm sure it understands it, exercising our discretionary authority, you have the same authority as the judge had in Tomasetti, which is broad as that of the Supreme Court. And considering the relevant factors, we find an award of additional interim counsel fees in the sum of $370,000 is appropriate. We would suggest that if the court didn't find, and I think they should, that the full amount of what we requested should have been granted, then at least what they should grant our actual time as of that time, which was my partner, actually, and also my son, $484,000. You may have noticed that we both have the same last name. Thank you all for your time.
Thank you.
I'm sorry
Thank
for
you.
keeping you so late. Thank you.